D'accord.
Qui disent la bande passante de votre réseau est faible. Ça veut dire quoi?
Ils ont changé les procureurs de la commune 1, 2, 4, 5. Nous sommes une amendissant. Nous avons le monsieur qui impose ici, ça c'est pour y arriver.
Good morning, good afternoon, ladies and gentlemen. Welcome to this online discussion put together by the African Court Coalition and the Pan-African Lawyers Union to discuss the important issue of judicial independence in Africa. Please, let's just give a minute or two for other attendees to join us, and then we can formally start. You're welcome, and we thank you for keeping time.
Hello everyone, welcome to today's webinar. Please note that this webinar is going to be broadcasted in 2 languages, that is English and French. Kindly ensure that you are on your desired channel. The following is the procedure on how to select your desired channel. For those joining today's session via laptops or tablets, at the bottom of your screens, there is an interpretation icon. Kindly click on it and select your language of choice. Ensure mute original audio is checked for you to clearly hear the presentation. For those joining via mobile phones, at the bottom of your screen, click More tab. Within it, you will see interpretation sub-menu. Click on it and select your language of choice. Ensure mute original audio is selected for you to clearly hear the presentation. Thank you all and enjoy the session.
Thank you very much. I think we are in a position to start. I will not say much today. My name is Donald Dyer. I head the Secretariat of the Pan-African Lawyers Union and sit on the steering committee of the African Court Coalition. And to deliver opening remarks on behalf of the African Court Coalition, and also to invite our session chair for the first session, I will now invite my sister, Ms. Rosalyn Hanzi, who's also a member of the steering committee. There's a chairperson of the steering committee of the coalition, and is also the executive director of the Zimbabwe Lawyers for Human Rights. Welcome, Rosalyn.
Thank you, Don. It is a great pleasure for me to welcome you to this webinar on behalf of the African Court Coalition and also the Pan-African Lawyers Union that have organized this session today. I would want to say to our participants, good afternoon, good morning, good evening, depending on where you are following us from. 2021 is a year when the role of the judiciary and the legal profession in defending human rights, the various constitutions on the continent, continues to be under the spotlight, especially considering the highly unusual environment that we are operating under across the African continent and indeed the world. Coronavirus pandemic has not only brought about unusual restrictions on fundamental rights and freedoms, but some repressive governments have continued to lock down rights, as it were, justifying their actions on the need to manage the spread of the virus. Equally compelling has been the developments witnessed in previously progressive democracies on the continent, where restrictions and failure to uphold fundamental rights and freedoms has started to take root. It is important to note that coronavirus has created a dangerous precedent, or rather unusual opportunity for governments to undermine rights, the rule of law, and rely on the excuse that they want to preserve rights such as the right to life and health. 2020, as the start of coronavirus restrictions, was not necessarily the start of the challenges that we'll be discussing today. Indeed, the critical role in the discourse on promotion of human rights of the judiciary that is independent at the institutional and individual level, supported by a legal profession that is functional, effective, and able to carry out its mandate, can never be understated as we discuss the democratization agenda on the continent. Allow me, ladies and gentlemen, to introduce some of the eminent panelists that we have today that are going to be leading the discussions that we'll be having this afternoon, this evening, or this morning, depending on your location. I'll start off by presenting to you and introducing the first speaker, who is the Honorable Judge Bernard Mwepe, the former judge of the African Court on Human and People's Rights. He is going to be presenting a topic to you on the importance of judicial independence as articulated under the African Charter and other instruments. And his presentation is also going to be followed by an eminent jurist, an eminent former commissioner of the African Commission on Human Rights, a lawyer, Mrs. Soyata Maiga, who is going to be presenting on independence of the legal profession. We'll then have another session that follows that is going to be focusing on how independent our courts are. And this session is going to be led by Ms. Kajal, who is the director of the International Commission for Jurists located in South Africa. And we are also going to be having another presentation on addressing corruption in the judicial systems, which is going to be led by Monsieur Suleiman Teliko from the Union des Magistrats du Senegal. And we'll also have a presentation that is going to be led by Monsieur Nuhu Abubakar, the Secretary General of the Syndicat Autonomie des Magistrats du Niger. And he's going to be followed by Mrs. Osai Ojigo, who is the director of Amnesty International Nigeria. She's going to be the last speaker for the first session that we are going to be having. I'll hand over to my moderators for this session. Thank you.
Merci à toi. Roselyne, je me permets de te tutoyer déjà. Et donc, si bien que vous nous avez recommandé de respecter le temps qui nous est imparti, il est tout à fait louable que je me présente, c'est tout. Je suis Fatia Messou-Sedili, le vice-président de l'Union panafricaine des avocats, et je suis contente, mais également honorée de modérer cette session qui regroupe en fait des éminentes personnes, donc des juristes, éminentes personnes qui vont nous échanger sur une question récurrente qui est l'indépendance du système judiciaire. Alors, sans trop m'attarder, j'aimerais bien céder la parole au juge Bernard Goépé, et excusez-moi pour la prononciation du nom, pour nous entretenir sur la raison d'être et l'importance de l'indépendance des tribunaux telle qu'elle est définie dans la Charte africaine des droits de l'homme et des peuples. Merci. Donc, et à vous la parole, monsieur le juge.
Thank you very much. Greetings to everybody. You can always call Bernard if you have problems with my surname. I love that first name as well. It was given to me by my mother. So it's fine, just fine. Yeah, thank you, everybody. I see familiar faces there. Soyata, I'm glad you're still there. I hope you're still as strong as ever. Don, others, Chu, and others. Please, thank you, everybody. I think Rosalind has already sketched a little bit the health context within which this discussion takes place and within which we experience challenges. She made reference to COVID problems and the like, but I just want to say a word about the political context, which is a problem and a threat to the independence of the judiciary. And I think the world over, excuse me, there seems to be a tendency to move towards the right. And that entails some grave dangers to the protection of people's rights and so on and so forth. It's not only happening in Europe and the like, it's happening even here within our continent. And that has been the problem. We've always had problems of entrenched dictatorships and the like, and some of whom think that they're above the law, which in itself is a threat to the independence of the judiciary. And some of them entrench themselves through fraudulent elections and so forth, which are not properly observed, but are observed by former politicians themselves, instead of being observed by independent people from NGOs and the like. You find opponents and journalists being harassed and the like. And but very disturbingly, there are some tendencies which directly go towards the undermining of the independence of the judiciary. There are attempts in some countries to try and take control of the judiciary by trying to determine who should be appointed a judge and who should not be. And that, of course, is a direct threat to the independence of the judiciary, because once politicians decide as to who should be a judge and who shouldn't be, then there's a problem. And also, in some countries, I've noticed, there's a tendency to try and have as much control and influence over the legal profession as possible. That is a problem, because it is through an independent and viable legal profession that we are able to mold people who eventually would end up being judges and who would have had nurtured in them a sense of strong conviction and a sense of independence. But as I say, there are some disturbing signs from other countries when governments want to have a lot of say and control over the legal professions. Now, this constitute, the context that I've explained, constitute a very serious threat to the independence of the judiciary. What then is the solution? Question may be asked, but I'm not King Solomon. I cannot give you all the solutions to the problems. I see there are a lot of important heads and wiser heads on the panel. They'll probably tell you a little bit more, but my view is that the ultimate solution is the upholding of the rule of law. Because when you uphold the rule of law, you've got stability, which gives you an environment in which economic development takes place, and people are able to express themselves freely economically and the like. Corruption is less amongst politicians and the like because there's economic development. And the migration of our people because of the sufferings that they go through is diminished in a situation we have got the rule of law. But then the million-dollar question is, how do you maintain the rule of law, which is in fact the ultimate defender of the basic rights of people, and which has got in it a mechanism to ensure an independent judiciary? Well, the first thing that is important, and I apologize to interpreters, I'm going too fast, but I want to just keep within the allotted time. The important thing is, that is the important thing towards ensuring an independent judiciary, is to make sure that we have got a mechanism that is dependable, that is apolitical, and that will identify and give to us people who are properly qualified to sit on the bench to be judges, and people who have in them a strong sense of independence. Now, I make this point because, again, you'll notice that in some countries, governments want to have a say in who should be appointed a judge. That is totally inconsistent with an independent judiciary. For example, in South Africa, in the past, the Minister of Justice, or in some countries, as they say, the Attorney General, would just pick up the phone and phone Don Dare and say, from next month, I want you to be a judge. And that was it. That's how they pick judges. So we need to have a strong mechanism that will identify judges a say in the appointment of judges, but at least to some extent, it is independent and is able to identify for us suitable candidates. Therefore, it's important to have a strong and independent, dependable mechanism that will identify people suitably qualified to be judges and who will therefore be independent once they are on the bench. The issue of security of tenure is very important because it will make sure that judges wouldn't mind risking unpopularity with politicians because they know that they've got security of tenure. The other thing that is important towards ensuring building a strong and independent judiciary is to have a strong and independent legal profession. I've already said that it's concerning that in some countries, governments want to undermine the importance of the legal profession. Well, the legal profession is important because it's a pool from which we hope to get judges in future. And therefore, please let us use all our resources to make sure that we build strong legal professions in our respective countries. Now, we need to respond to unwarranted attacks on the judiciary. For example, in South Africa, politicians, whenever they get judgments against them, judgments they don't like, they go on an unwarranted attack on the judiciary. What we therefore, as a solution, need to do as non-governmental organizations and the like, is to have a collective effective response to unwarranted attacks on the judiciary, because unwarranted attacks on the judiciary tend to undermine the confidence of the people in the judiciary. So, which results in a threat to the independence of the judiciary. Something else again that we need in order for us to have an independent judiciary is to have an active and strong NGOs that will speak out, that will, as you're doing now, mobilize and arrange and have some teachings, organizations and workshops and discussions, and speak about against the undermining of the independence of the judiciary. This period that Roslyn has referred to, the COVID period, has just made some of us realize how much valuable time we wasted in the past, while we could still interact freely throughout the continent, while we could still move freely throughout the continent. Suddenly we appreciate how valuable time we lost. I hope that when this period is over, we will be able to again interact and mobilize to achieving things such as the independence of the judiciary. I once complained to, and this is another point, while I was still the vice president of the African Court in the AU, at the AU's headquarters, I once questioned European ambassadors. I say, you are good in giving out aid to the African Union and African countries. Why don't you make it a condition to the aid that you give to say, on condition you respect the judiciary, on condition you respect human rights? And I think we should tell them more and more that they seriously need to attach that as a condition for their aid. But you know why they don't do that? Because the problems of Africa is not theirs. Whether you are the independence of their judiciary is undermined, that is not their problem. They only complain when Trump undermines the judiciary of America or Europe and the like. So there again, we need to tell them that they need to attach conditions to the grants that they give. And another point, and I'm speaking particularly to the NGOs and the legal profession, we need to litigate against offending governments. And we used to do this in South Africa during apartheid. We would go to court, even if we knew that we'll probably lose, but we would go to court, take cases to court, and sometimes you throw some light on issues which were otherwise under cover of darkness by going to court. Let us litigate and litigate and litigate if that will help us to protect human rights and, of course, to strengthen the independence of the judiciary. Another point, let us, in our workings, collaborate with the media. I never stop marveling at the importance of the media in the country. The media is like a torch. It shines onto dark corners in the country. And we therefore need to work in collaboration with the media to make sure that we protect human rights and, of course, the independence of the judiciary. I don't have to go into details. You know the importance of the media. I want to keep within my allotted time because I know a lot of people have got a lot of things to say, very, very important things to say. But let me close my remarks by this. I think we need to build a very strong continental jurisprudence that will teach us not only human rights, but will go right down, filter down to every single country to say human rights are important and you cannot be in a position to protect human rights unless you have a strong and independent judiciary. This is the reason why, while we're at the African Court, we used to invite chief justices and other leaders throughout the continent, judicial leaders throughout the continent, to come and talk with us, to interact with us, because we need to build a continental jurisprudence that will say to people, respect the judiciary, If you respect the judiciary, you'll be able to protect the rights of people. Thank you. I hope I've stayed within my time.
Thank you, Honorable Judge Mwepe.
Merci. À mon tour de le remercier pour avoir justement respecté le temps qui lui était imparti et surtout pour nous avoir échangé sur les aspects primordiaux relatifs à l'indépendance du système judiciaire et surtout par rapport au mandat des juges et la modalité de leur nomination. Et surtout que l'honorable juge Bernard a évoqué surtout des solutions pratiques par rapport notamment aux conditions que l'Union africaine peut imposer comme les conditions tributaires de l'octroi de l'aide. Et une autre solution que moi aussi je trouve très pratique et pertinente qui concerne le fait d'impliquer les journalistes, et nous savons tous que les journalistes constituent c'est le pouvoir, le quatrième pouvoir, pour justement s'assurer du respect des droits de l'homme et de l'indépendance du système judiciaire. Merci beaucoup. Je passe directement la parole à Maître Sayata Maïga, notre avocate et ancienne présidente de la Commission africaine des droits de l'homme et des peuples, pour aborder la question de l'indépendance de la profession juridique. À vous la parole, chère consoeur. Maître Maya. Maître Soyata, est-ce que vous nous entendez? Est-ce que vous pouvez prendre la parole?
Ça va, vous m'entendez?
Oui, là, oui.
Là, vous m'entendez? Ok, d'accord, très bien. Donc, je voudrais remercier les organisateurs de cet exercice auquel nous avons été conviés. Évidemment, en 7 minutes, on ne peut pas avoir une vision holistique de tous les problèmes. Et j'adhère complètement à tout ce qui vient d'être dit par le juge Bernard, parce que de mon point de vue, on ne peut pas dissocier l'indépendance des pouvoirs judiciaires, l'indépendance de la profession juridique. Elles sont imbriquées et il faut effectivement qu'elles se soutiennent mutuellement, et souvent, c'est l'indépendance de la profession libérale ou qui devrait pouvoir soutenir, comme il l'a dit avec les ONG et les médias, l'indépendance de l'appareil judiciaire. L'édification de l'état de droit et de démocratie, un état de droit et de démocratie, n'est possible qu'avec l'existence, on l'a dit, tout le monde le sait, d'une justice performante au sein de laquelle toutes les conditions sont créées pour que soient respectés et s'exercent les droits et libertés des citoyens sous le contrôle de la loi, de certains mécanismes également, mais avec l'accompagnement d'un barreau fort, intégrant les règles et principes qui déterminent son organisation et son fonctionnement. Dans plusieurs pays africains, nous avons vu qu'à la lumière des révisions constitutionnelles, que la Constitution a élevé la justice au rang de pouvoir judiciaire, en garantissant l'indépendance vis-à-vis des pouvoirs exécutifs et des pouvoirs législatifs. Or, dans la pratique, à quoi on assiste? Et en dépit donc des efforts de nombreux pays dans la conduite des réformes dans le secteur de la justice, accompagnés d'investissements souvent importants pour améliorer les conditions de vie et de travail des magistrats, la justice dans plusieurs pays n'a pas réussi à réaliser son indépendance. Pas seulement à cause de la part insignifiante du budget national qui lui est attribué. Au Mali, c'est moins de 2%. Mais surtout, en raison de l'absence d'une volonté politique réelle de la part de nos gouvernants et aussi de la persistance de pression de plusieurs ordres qui s'exercent sur la justice. Influence du pouvoir exécutif, on l'a dit, pression de la rue, corruption et pression des groupes financiers et des multinationales, pression des leaders religieux, des chefs coutumiers, pression de la parenté sociale. Ici ajoute, dans les pays comme le mien, en conflit et où sévit le terrorisme, les enlèvements et autres atteintes à l'intégrité physique des juges, les attaques ciblées contre les prisons et les lieux de détention qui ont fait déserter le personnel de l'administration pénitentiaire et judiciaire de plusieurs localités et régions, où l'autorité de l'État et son utilité sociale ont complètement disparu. Le pouvoir judiciaire donc a fini par se révéler comme un instrument entre les mains des pouvoirs exécutifs et législatifs. L'école vote le budget de la justice et retiennent à sa place des choix opérationnels en matière de politique criminelle, en matière de nomination des procureurs, en matière également de nomination des juges dans les hautes juridictions. Il a été souvent imposé au pouvoir judiciaire d'arrêter des poursuites en cours contre des présumés terroristes, d'organiser des échanges et des libérations sélectives d'auteurs de crimes de sang, de prendre et de faire exécuter des décisions à fort élan politique, en violation flagrante des lois au nom de la paix sociale, de la stabilité des institutions en place ou pour satisfaire des impératifs politiques dictés par des exigences de partenaires extérieurs engagés aux côtés des pays concernés. Les citoyens au nom desquels la justice est rendue en sont arrivés à une situation de dépit en raison de sentiments d'injustice que certaines sentences rendues par les juridictions nationales, ordre judiciaire et constitutionnel ont engendré, lesquelles ont été porteuses souvent de troubles sociaux, comme ça a été le cas au Mali. De plus en plus, donc, dans certains pays, on assiste à des actes de défiance des populations vis-à-vis de la justice et des juges. Et cette tendance, malheureusement, n'épargne pas les avocats, dont le rôle est souvent incompris et décrié lorsqu'ils défendent des présumés corrompus, des terroristes ou des putschistes. Dans les textes contemporains, ont effectivement scellé l'indépendance de l'avocat, comme la DIDH, les pactes internationaux, et qui ont été suivis de principes onusiens. Mais je pense que nous devons, à partir de ces principes, à partir de ces règles, repenser effectivement l'indépendance de la profession libérale en nous collant à la réalité, en faisant une évaluation de la réalité au niveau d'un certain nombre de pays et de voir effectivement quelles sont les contraintes objectives et quels sont effectivement les ressorts qu'on devrait effectivement reconstruire à l'effet de permettre à la profession juridique de s'exercer au bénéfice des citoyens et de la loi. Ainsi, dans les pays qui font face au terrorisme et aux conflits armés, les avocats se sont vus confrontés à des défis immenses face à la perpétration par les acteurs étatiques et de sécurité ou des milices privées de crimes graves, y compris les exécutions extrajudiciaires et sommaires ayant entraîné, entre autres, des milliers de morts civiles, des attaques contre des cibles non militaires, des migrations illégales et la traite des êtres humains, l'enlèvement des enfants et leur utilisation dans des groupes armés, ainsi que les agressions sexuelles contre les femmes et les filles. L'insécurité, dans certaines zones où les crimes sont perpétrés, a réduit la capacité. Et lorsque les barreaux locaux n'ont pas la capacité, on ne peut pas parler d'indépendance. Ces barreaux sont confinés dans les capitales. Les avocats sont dans les capitales ou les grandes villes, ce qui les empêche d'accéder aux victimes et aux preuves lorsqu'ils sont constitués pour assurer leur défense. Cet environnement et ces tendances observées permettent à ceux qui commettent des crimes assimilés aux crimes de guerre et aux crimes contre l'humanité de rester impunis. Il se pose là, donc, plus généralement, un problème de viabilité, d'existence même de nos appareils judiciaires, du système judiciaire dans son ensemble, lorsqu'il se révèle incapable de mobiliser les moyens sécuritaires, humains et logistiques nécessaires pour rechercher, traduire et juger les auteurs complices d'infractions graves. Dans un contexte donc de crise politique et sécuritaire, le juge Bernard en a parlé, caractérisé par l'affaiblissement des fondements de l'État, comment repenser l'indépendance de la profession juridique. Malgré ces contraintes, les barreaux s'organisent et ont compris avec l'accompagnement des communautés économiques régionales qu'il faut harmoniser les règles, il faut aller à la formation, il faut également être des acteurs contribuant à la mission de service public de la justice. Ainsi, pour beaucoup d'observateurs, comme je l'ai dit, l'indépendance de la profession juridique devrait soutenir l'indépendance du pouvoir judiciaire, dont il est tributaire. Les magistrats chez nous, et je pense que c'est le cas dans plusieurs pays, sortent des mêmes écoles que les avocats, ils évoluent dans le même milieu professionnel, se complaisent dans les tares du système judiciaire, dans les dysfonctionnements, avec les influences, avec les complicités, sans rupture véritable, ni dénonciation ou réquisition des juges par les avocats dans les cas de corruption, de conflits d'intérêts, d'incompétence ou de problèmes de probité. Certains éléments peuvent être retenus pour renforcer les barreaux et les sortir justement de cette torpeur, leur permettre d'exercer véritablement leur indépendance au profit effectivement de l'état de droit et des intérêts des citoyens. Ainsi, il faut le renforcement des règles déontologiques, d'éthique et de probité, l'établissement des mécanismes internes qui contrôlent cette indépendance. Non seulement l'indépendance des juges, mais également l'indépendance des avocats pour éviter toute entente ou complicité. On a souvent entendu qu'il y a des juges commerçants et des avocats commerçants. Ils commercent entre eux. Au détriment de la responsabilité. Parce qu'il y a des textes qui autorisent ou qui effectivement permettent de la mise en responsabilité des juges et même des avocats, qui ne sont jamais utilisés. Et donc, cette responsabilité, elle est corollaire de l'indépendance parce qu'on ne peut pas avoir des pouvoirs sans contre-pouvoir. De mon point de vue, cela est essentiel. Il faut le renforcement aussi de la formation continue, pour que, en y intégrant l'élargissement du cadre de l'exercice professionnel des avocats en vue de les encourager à saisir les juridictions régionales. On a vu dans plusieurs pays, surtout ceux qui sont en conflit, que la justice n'est pas disponible. Elle n'est pas là, elle ne peut pas garantir l'exercice des droits fondamentaux des citoyens, alors que dans le même temps, nous avons la Cour africaine des droits de l'homme et des peuples, la Cour de justice, la CEDEAO, d'autres cours au niveau de la sous-région de l'Afrique de l'Est, qui ne sont pas saisis par les avocats, simplement parce que, effectivement, même avant la pandémie que nous connaissons, il n'y a pas suffisamment de ressources affectées à l'assistance judiciaire et effectivement à ce interéchange qui est fondamental entre les cours régionales et les tribunaux, entre les avocats, également au niveau national, au niveau régional. Il faut également, de mon point de vue, des programmes de travail annuels entre les juridictions régionales et les barreaux sur la jurisprudence et sur les sujets d'intérêt commun. Le juge Bernard en a parlé, la multiplication de salles d'échange et de perfectionnement des jeunes avocats entre les instances communautaires respectives, la création de structures associées regroupant plusieurs avocats pour faire en sorte que le service public de la justice soit accessible à tous, pas seulement dans les capitales, mais dans les régions reculées où les citoyens ne connaissent pas leurs droits et ne peuvent pas exercer les voies de recours, faute d'orientation adéquate. Il faut la dotation en équipement, outils informatiques, bibliothèques, publications et vulgarisation régulière des textes et de la jurisprudence disponible. L'établissement d'une aide juridique pérenne et des services de l'assistance judiciaire dotés de moyens financiers suffisants dans le respect de l'indépendance du barreau. Une plus grande interaction également avec les coalitions d'ONG qui luttent contre la corruption et pour la défense des droits de l'homme. Le soutien des ONG de défense des droits de l'homme, de mon point de vue, qui ont une expertise avérée dans ce domaine-là, est essentiel pour soutenir toute réforme, pour soutenir évidemment l'indépendance de la profession juridique et l'indépendance des magistrats. L'utilisation des médias, on a vu dans certains pays qu'il y a des résultats d'enquêtes d'opinion qui ont été vulgarisés et qui ont été menées pour jauger effectivement le sentiment des citoyens par rapport à l'administration de la justice et comment la justice est distribuée. Et nous avons vu que les citoyens et même les magistrats et les avocats étaient très attentifs à connaître l'opinion effectivement des citoyens. Donc nous pensons que les enquêtes d'opinion sur l'administration de la justice et les acteurs de la justice, ces enquêtes d'opinion sont très, très importantes. Il faut les intégrer à toute réforme. Il faut également, depuis un certain temps, au niveau de l'Union africaine, on parle de l'établissement d'un fonds d'assistance judiciaire. On a nommé les administrateurs de ce fonds, mais le fonds peine effectivement à lancer ses activités. Et nous pensons que après effectivement cette pandémie et ses conséquences sociales et économiques sur nos pays, il est fondamental de pouvoir voir dans quelles conditions la justiciabilité des droits sociaux et économiques peut être engagée, et cela ne peut se faire qu'avec un fonds d'assistance, un fonds également d'indemnisation. On a vu au niveau des Nations Unies qu'il y a toujours un fonds de contribution volontaire, pourquoi pas en Afrique, pour permettre effectivement aux avocats, mais également aux ONG de faire ce travail d'interaction à l'intérieur des pays, mais également au niveau régional et international, de façon à pouvoir effectivement contribuer à la promotion d'état de droit, d'état de démocratie, parce que, comme on l'a dit, il y a la récession, et cette récession risque effectivement de durer. Nous devons donc repenser à comment inverser les tendances de contre-performance qui est testé des appareils judiciaires et des professions libérales. Je pense que les conclusions auxquelles nous allons aboutir vont nous permettre de réfléchir davantage et de voir l'adaptabilité au niveau de chaque pays, au niveau de chaque sous-région, de façon à avoir effectivement des recommandations adaptées. Merci. Merci, merci.
Merci, je suis désolée, j'étais obligée de vous interrompre.
Non, c'est bon.
Pourtant, vous nous avez échangé sur des points très intéressants par rapport, je vous félicite surtout d'avoir parlé de cette interconnexion entre le système judiciaire, l'indépendance du système judiciaire et la profession, et l'indépendance de la profession juridique, et la panoplie de solutions que vous avez bien voulu proposer. Je vous en remercie. Vous avez aussi mis l'accent sur la corruption et la connivence entre le système, entre les avocats peu scrupuleux et les magistrats peu scrupuleux également. Et je crois que c'est ce point-là que M. Noou Abdelboubaker, qui va nous entretenir plus spécialement dans le cadre de la lutte contre la corruption dans l'institution judiciaire. Donc, je donne la parole à M. Aboubakar, pour donc présenter quelques remarques sur la lutte contre la corruption dans l'institution judiciaire. Monsieur Aboubakar, est-ce que vous m'entendez? Bon, je reviens alors à Monsieur Aboubakar. En attendant, je reviens plutôt aux observations qui ont été évoquées par Maître Sayata et les défis auxquels les avocats du Mali ont été amenés à affronter. Elle a également évoqué la question de savoir comment repenser justement quelles sont les solutions préconisées pour justement garantir l'indépendance du système judiciaire et je disais la panoplie des solutions qu'elle a présentées. Alors, je reviens, monsieur...
Fatia, je m'excuse, je pense que c'est Kajal qui doit intervenir et non Aboubakar.
Pardon? Ah, je m'excuse.
Ça doit être Kajal qui doit intervenir.
Oui, c'est moi qui ai...
Thank you, Fatia.
C'est Kajal, alors je suis vraiment désolée parce que un point très intéressant qui a attiré mon attention, qui a été évoqué par Maître Malga. Et c'est vrai, une réalité, c'est cette connivence entre les avocats et juges au détriment des justiciables. Et ça, c'est aussi un problème qui se pose même au niveau des pays de l'Afrique du Nord dont je fais partie. Alors, le maître Kajal, elle va nous entretenir sur le point de savoir si nos cours sont vraiment indépendantes ou pas. Donc, en évoquant les qualifications et procédures de sélection, les modalités de nomination, les conditions de service et emploi, l'immunité, discipline, etc. Alors, excusez-moi pour ce malentendu. Donc, et je donne la parole à Kajal.
Thank you, Fatia. Thank you so much. I'm going to speak about how independent are our courts. I have a very specific brief for this presentation. I'm going to refer in this presentation primarily to the Bangalore Principles of Judicial Conduct, as well as the United Nations Basic Principles on the Independence of the Judiciary. I do this to set out the standards in respect of the treatment of judges. I will briefly cover the elements as they are set out in the program. And in the interest of time, I will not state the particular articles or sections which are very easily accessible. To start off with speaking about qualifications, selection, and training. Persons are selected for judicial office shall be individuals of integrity and ability with appropriate training or qualifications in law. Any method of judicial selection shall safeguard against judicial appointments for improper motives. In the selection of judges, there shall be no discrimination against a person on the grounds of race, color, sex, religion, political or other opinion, national or social origin, property, birth or status, except that a requirement that a candidate for judicial office must be a national of the country concerned, that shall not be considered discriminatory. In respect of the tenure of judges, a judge should have a constitutionally guaranteed tenure until a mandatory retirement age or the expiry of a fixed term of office. Except pursuant to a system of regular rotation provided by law, a judge should not be transferred from one jurisdiction, function, or location to another without their consent. Appointment procedures may differ between states. However, these are closely regulated, most often and most frequently by a body called the Judicial Services Commission or a similar body. I will relate two cases which are relevant on this point regarding appointment procedures. The first concerns a case from Botswana, a 2015 case from Botswana, Law Society of Botswana versus the President. Regarding judicial appointment, following an interview, the Judicial Services Commission recommended a candidate for appointment. The President declined to appoint this individual without giving any reasons for this. The key issue in the case is the proper interpretation of a section of the Constitution on appointment. And this particular section states the individual shall be appointed by the President, acting in accordance with the advice of the Judicial Services Commission. This matter was heard by the full bench before the Court of Appeal, and the court found that the President is obliged to act in line with the recommendations made by the Judicial Services Commission, and that the President may not depart from the recommendations and to select their own candidate. The second case, which is from Malawi, concerns the attempts to remove the Chief Justice Andrew Nyirenda. Many of you will remember this case from middle of last year, from 2020, and it concerns the attempt by the executive in Malawi to place the Chief Justice, as well as the second most senior judge in Malawi, on indefinite leave pending retirement. This move preceded the hearing of the election petition, and the High Court granted an injunction preventing this move. The state's action was viewed as an unprecedented attack on the independence of the judiciary. Moving on to conditions of service and tenure, the UN Basic Principles states that the term of office of judges, their independence, their security, adequate remuneration, conditions of service, pensions, and the age of retirement shall be adequately secured by law. Regarding immunity for judges, a judge should be held criminally liable under the general law for an offence of general application committed by them and cannot therefore claim immunity from ordinary criminal processes. A judge, however, should enjoy personal immunity from civil suits for conduct in the exercise of a judicial function. The remedy for judicial errors, whether in respect of jurisdiction, substance, or procedure, should lie in an appropriate system of appeals or judicial review. The remedy for injury incurred by reason of negligence or misuse of authority by a judge should lie only against the state without recourse by the state against the judge. Since judicial independence does not render a judge free from public accountability, and legitimate public criticism of judicial performance is a means of ensuring accountability subject to law, a judge should generally avoid the use of the criminal law and contempt proceedings to restrict such criticism of the courts. Looking at discipline, suspension, and removal, a charge or complaint made against a judge in his or her judicial and professional capacity shall be processed expeditiously and fairly under an appropriate procedure. The judge shall have the right to a fair hearing. The examination of the matter at its initial stage shall be kept confidential unless otherwise requested by the judge. Judges shall be subjected to suspension or removal only for reasons of incapacity or behaviors that renders them unfit to discharge their duties. All disciplinary suspension or removal proceedings shall be determined in accordance with established standards of judicial conduct. And finally, to speak about judicial independence in the context of Zimbabwe, in 2018, the Zimbabwean Constitutional Court dismissed a constitutional challenge which sought to access voting for Zimbabwean citizens resident outside the country. The court in this case, when it dismissed this challenge, missed a golden opportunity to implement universal suffrage in Zimbabwe. This appeared to be a political decision rather than one based on the applicable laws. The outcome of the case was a huge disappointment to the thousands of Zimbabweans in the diaspora who had been unable to register as voters and who were unable to travel to Zimbabwe to participate in those elections. It is surprising that the court did not consider options of progressive realization of the right to vote for all citizens, including for those outside the country. And finally, to talk about the guarantee of non-interference. The independence of the judiciary shall be guaranteed by the state and enshrined in the constitution or the laws of the country. It is the duty of all government and other institutions to respect and observe the independence of the judiciary. Thank you.
Merci pour cette présentation exhaustive, Kajal, surtout sur les points que vous avez bien voulu évoquer par rapport à l'influence politique dans le processus de nomination des juges qui effectivement empêche l'indépendance des systèmes judiciaires. Merci aussi pour avoir évoqué des solutions qui concerne la sécurité du mandat des juges. Et ça aussi, c'est un aspect important relatif à l'indépendance du système judiciaire. Je passe alors maintenant à l'intervenant suivant. Excusez-moi, je ne veux pas faire d'erreur comme tout à l'heure. Et voilà, donc c'est Monsieur Aboubakr qui doit prendre la parole maintenant pour nous entretenir sur la question de la lutte contre la corruption dans l'institution judiciaire. Monsieur Aboubakr. Est-ce que M. Aboubakar a un problème de connexion ou de...
Malheureusement, il n'est pas sur la liste, donc on peut continuer avec le programme.
Effectivement, donc, si vous voulez, alors je passe. Est-ce que M. Souleyman est là?
Oui, je suis là.
Et alors, bienvenue, M. Souleyman. Vous allez nous entretenir sur le point de vue sur la capture judiciaire et excusez-moi, la persécution de l'organisme civique.
Merci. Je vous remercie, madame. Je voulais axer mon intervention, puisque je n'ai pas beaucoup de temps, 7 minutes, on m'a dit.
Oui, malheureusement.
Sur 3 aspects. je suis président de l'Union des magistrats sénégalais.
Enchanté.
J'imagine que c'est peut-être la raison pour laquelle on m'a désigné. Voilà, donc mon intervention va être axée sur 3 points. Le premier, c'est sur le fait que l'organe de poursuite, chez nous, il est sous la subordination de l'exécutif. Et ça, nous estimons que c'est quand même un problème dans la mesure où les magistrats du parquet sont d'abord des magistrats. Alors, chez nous, tous les magistrats sont formés dans la même école. Et quand ils sortent, ils sont affectés parfois au parquet, parfois au siège. Les magistrats peuvent quitter le siège pour aller au parquet, peuvent quitter le parquet pour aller au siège. Donc, ils ont des attributions juridictionnelles. Le fait de mettre cet organe de poursuite sous la subordination de l'exécutif, ça pose problème dans la mesure où ça permet indirectement à l'exécutif de s'immiscer dans le traitement des affaires judiciaires. Un exemple concret qu'on prenait, c'est qu'un procureur de la République, quand il reçoit des institutions écrites, il est obligé de s'y conformer, sinon il commet une faute disciplinaire. Et donc, le ministre de la Justice, il peut enjoindre à un procureur de poursuivre quelqu'un.
Je m'excuse, M. Souleyman, est-ce que vous pouvez... Il n'y a pas d'interprétation en langue anglaise, donc si vous pouvez nous donner 2 minutes, comme ça on peut parler avec les interprètes. Merci.
Il y a un problème d'interprétation.
Moses, you can continue. Go on, Moses.
OK. Alors, M. Souleyman, vous pouvez continuer votre intervention.
Je continue alors?
OK, vous pouvez continuer, M. Souleyman. Oui.
Voilà. Donc, je disais tout à l'heure que donc, le premier aspect, c'était la subordination de l'organe de poursuite, qui est le parquet, à l'exécutif. Et cette subordination fait qu'indirectement, on permet à l'exécutif de donner des ordres à un magistrat qui exerce des attributions juridictionnelles. Par exemple, l'ordre de poursuivre quelqu'un, l'ordre de faire appel, sachant que chez nous, quand vous faites appel, la personne est maintenue en détention, etc. Indirectement, donc, c'est une manière pour l'exécutif de s'immiscer dans le traitement des affaires juridictionnelles, et ça arrive souvent, notamment dans les affaires sensibles qui intéressent l'État. Deuxième aspect, c'est par rapport au siège, aux juridictions. Là, le principe, c'est que les juges sont censés être indépendants, c'est vrai, c'est le principe, mais nous savons que l'indépendance, c'est à la fois une dimension personnelle, mais aussi une dimension institutionnelle. Il faut que le magistrat puisse bénéficier de garanties lui permettant d'exercer son office en toute sérénité. Et le principe d'inamovibilité, ça sert à ça, ça sert aussi à assurer un certain confort statutaire aux magistrats. Le Conseil supérieur de la magistrature aussi permet à un magistrat d'avoir une carrière fondée sur le mérite, sur l'excellence, etc., fondée sur des critères précis. Or, là aussi, ce que nous remarquons, c'est que ces garanties institutionnelles ne sont pas suffisantes, d'une part, et d'autre part, elles ne sont pas respectées. Elles ne sont pas respectées. Récemment, nous avons eu un cas d'ailleurs, un magistrat qui est président de juridiction, à qui on avait donné des injonctions, de manière informelle bien sûr, qui avait refusé, conformément à son statut, qui lui fait obligation de travailler en toute impartialité et en toute indépendance. Et quelques semaines après, il a été affecté, manu militaire, en violation du principe d'inamovibilité. Parce que chez nous aussi, c'est le principe, il comporte des exceptions, notamment les nécessités de service, et ces exceptions finissent par vider le principe de toute sa substance. Donc ça veut dire que déjà ces garanties-là sont insuffisantes. Et non seulement elles sont insuffisantes, mais l'organe principal qui est chargé de faire respecter ces garanties, à savoir le Conseil supérieur de la magistrature, cet organe, il est sous la tutelle de l'exécutif. Et donc, moi, je considère que c'est un paradoxe. On ne peut pas prendre un organe qui est chargé de faire respecter les garanties statutaires d'indépendance, de protéger les magistrats contre les velléités d'arbitraire de la part de l'exécutif, et mettre cet organe-là sous le contrôle et la tutelle de ce même exécutif. Et malheureusement, c'est ça. Et ce contrôle par l'exécutif se traduit par le fait que c'est l'exécutif qui dirige le Conseil. C'est le président de la République qui est le président, le ministre qui est le vice-président. C'est l'exécutif qui exerce les prérogatives essentielles. C'est l'exécutif qui propose au poste de nomination selon ses propres critères et de façon discrétionnaire. Donc, ça veut dire qu'aujourd'hui, un magistrat, il sait que sa carrière dépend du bon vouloir de l'exécutif. Ça montre déjà à quel point aujourd'hui les magistrats sont soumis, les magistrats du siège sont soumis de manière statutaire à l'exécutif. Et ça aussi, ça peut avoir un impact sur le comportement de certains qui peuvent être enclins à avoir des attitudes de docilité pour s'aménager une carrière prometteuse ou remplie. Troisième aspect de cette dépendance des juges, une dépendance qui est en porte-à-faux avec le principe d'inamovibilité, c'est que chez nous, on a institué une réforme sur la retraite et certains, on considère désormais certains peuvent aller jusqu'à 68 ans, mais l'âge normal, c'est 65 ans. Mais le problème, c'est que pour la condition pour aller à 68 ans dépend exclusivement de la volonté de l'exécutif. Ce n'est pas un critère objectif. Si l'exécutif vous nomme à des postes de chef de cour, vous avez le droit d'aller jusqu'à 68 ans. S'il ne vous nomme pas, vous partez à la retraite à 65 ans. Ça aussi, c'est une dépendance qui me semble incompatible avec l'esprit d'indépendance. Un magistrat qui a 64 ans, aujourd'hui, il est suspendu à la volonté de l'exécutif pour savoir est-ce qu'il va aller à la retraite à 65 ans ou est-ce qu'il va aller à la retraite à 68 ans. Parce qu'il n'y a pas de critère objectif. Le seul critère, c'est d'occuper un poste de chef de cour et l'occupation de ce poste dépend de la volonté exclusive de l'exécutif. Ça, nous avons considéré au niveau de notre union que c'est une atteinte à l'indépendance des juges et qu'il faudrait subordonner la prorogation à des critères objectifs comme le grade, l'ancienneté, etc. Troisième aspect, c'est maintenant l'union des magistrats. Parce que nous considérons aussi que la liberté d'expression, c'est un élément essentiel de l'indépendance de la justice. Il faudrait que les magistrats puissent, à l'occasion notamment des affectations, puissent donner leur point de vue, dire est-ce que ces affectations ont été faites dans les règles et éventuellement inviter les collègues aussi à former des recours. Ce que nous avons fait dans le cas que nous avons cité, que je vous ai cité tout à l'heure, nous avons invité notre collègue à former un recours devant la Cour suprême pour faire annuler, parce que nous estimons que c'est de cette manière-là que nous pourrons aussi assurer ou inviter les autorités à respecter le principe-là. Et il s'en est suivi d'ailleurs beaucoup de péripéties, parce que moi-même j'ai fait l'objet de poursuites pour ça, parce qu'on a estimé que dans mes déclarations, j'ai porté un préjudice à la crédibilité de l'institution judiciaire. Vous voyez? Et ça, c'est un précédent dangereux pour nous, parce qu'on ne peut pas aujourd'hui diriger une association de magistrats sans porter un regard critique sur le fonctionnement de la justice. Je le dis toujours que quand un magistrat dit que cette justice ne fonctionne pas très bien, ce n'est pas pour discréditer la justice, au contraire, c'est pour en améliorer le fonctionnement. Mais le fait de poursuivre un dirigeant d'association juste parce qu'il a critiqué le fonctionnement de la justice, pour moi, c'est une atteinte à la liberté d'expression des magistrats et c'est une manière aussi d'imposer la loi du silence face à des violations systématiques des principes. Et ça, c'est un précédent que nous jugeons dangereux. Nous faisons l'affaire sur son cours, nous allons former un recours sur ça. Mais je pense que ça, c'est la première fois, chez nous en tout cas, qu'un président de l'Union des magistrats est poursuivi pour cette question-là. Et voilà les quelques points sur lesquels je voulais intervenir. Le premier point, donc, je récapitule, c'est la subordination de l'organe de poursuite à l'exécutif, qui permet à cet exécutif d'intervenir indirectement dans le traitement des affaires judiciaires. Le second, c'est l'insuffisance des garanties statutaires accordées aux magistrats, et insuffisance symbolisée par le fait que le Conseil supérieur est sous la coupole et la tutelle de l'exécutif. Troisième aspect, c'est la remise en cause de la liberté d'expression des magistrats, qui s'est traduite par la poursuite d'un président de l'Union des magistrats, juste parce qu'il a déclaré que dans certains de ces aspects, la justice ne fonctionne pas bien. Voilà. Merci.
Merci pour cette présentation et pour la concision aussi. Je m'en tiens à la récapitulation que vous venez de faire. Donc, vous avez évoqué ces 3 points, vous les avez récapitulés. Et donc, je passe directement la parole au directeur, à Osaï, excusez-moi l'expression, la prononciation du nom, Osaï Ozigo, directeur d'Amnesty International de Nigeria, pour nous échanger, nous entretenir sur le même point de vue, donc par rapport aux captures, la capture judiciaire et la persécution de l'organe civique. Je vous donne la parole. Osaï, si vous m'entendez.
Yes, I can hear you,
Okay.
Madam Chair.
Okay, thank you.
Thank you very much. So I'm trying to share my screen briefly. I have a short presentation. I would like to thank the Pan-African Lawyers Union, the African Coalition, for making it possible for us to have this important conversation today. Okay. I hope you can see briefly. I'm trying to. Voila. Okay, thank you so much. So I'll just go quickly into my presentation. I wanted to focus a bit on Nigeria as a country of interest, to share that some of the experiences we're seeing of judicial capture across the continent is something that is endemic in the structures and the way the judiciary has been construed in our various jurisdictions. So just to highlight that when we look at some of the cases of concern and attack on civic space in Nigeria in particular, there are certain trends that we've noticed. One of it is the harassment and targeting of journalists. Oftentimes, they bring these cases to the judiciary, to the courts, and they tend to be frivolous cases. And the way the courts interact when these cases come is something that I think needs to be interrogated a bit further, because we know that when these attacks come, they will not come in the form of an issue that the journalist is dealing with, but rather it would come as a criminal charge against the journalist. So how do our courts respond? And are they sensitive enough to identify these issues when they come before them? Another issue is threats and attack on human rights defenders. This is increasing. We are finding situations where people are picked up from their homes, people are accused of undermining the state, accused of serious crimes like terrorism, in order to get them out of the system so that they can continue to perpetrate and oppress the people. One interesting trend that has also emerged in Nigeria is the issue of election petitions. And we found very surprising and very dangerous precedents whereby the Supreme Court of Nigeria is having to decide on who becomes the elected representative of the people. So it has moved from the ballot box, and election petitions have been decided in the courts of law. And most recently, a decision that led to a governor being elected, even though he did not get the majority votes in that particular election, has now led to people seeking some sort of, has now led to a situation whereby the judiciary seems to be the one that is appointing the executive governors of these particular states when these petitions come before them. Shockingly, about 2 years ago, the Chief Justice of Nigeria was removed. And it's an interesting development because ordinarily, the Chief Justice of Nigeria has protection under the Constitution and cannot be removed until he or she has attained the mandatory retirement age. But in a very interesting web and political intrigue, we found a situation whereby the Chief of Justice of Nigeria was accused of not properly declaring his assets, corruption, and was forced to resign in order to vacate that position. And we are seeing that increasingly this has led to lots of fear within the judges because they don't know who is next and they don't know who else could be targeted. So when cases come before the judiciary, like in the cases of the journalists I highlighted first of all, you find that there are cases because of something they've written, something they've said, something they've shared. But oftentimes they'll be arrested, they'll be detained, and you find that when the lawyers for these journalists come before the courts and ask for remedies, they are not often given because they are treated as criminals. They are not treated as people who are before the courts because they are exercising their freedom of expression, that their human rights have actually even been violated. And this is a worrying concern in showing that the judges seem to be more worried about what the state executive would do to them rather than actually streamlining the course of justice. Delays in the court system, this has been highlighted before, but mostly around the fact that cases take too long and then in effect makes it difficult for claimants to state the true cause when they are challenging certain issues before the court system. And finally, we are finding a trend whereby even when the courts, against all odds, produce court orders, make declarations, order state agencies to actually release people who are in detention. We have so many cases in Nigeria, and just to highlight cases of the leader of the Islamic movement of Nigeria cleric, he's been in detention despite orders from the court saying that he should be released. It gives signs of a worrying decline of judicial independence and also the fact that the judiciary's powers are being undermined overall in the country. So just to summarize that, when we look at what are these things that the judiciary are facing and where are also the opportunities that can be used to reclaim judicial independence and save them from the state capture that we're seeing. The first is the selection and appointment of judges. And the second is financial autonomy. If I would dwell a bit more on the selection and appointment of judges, you'll find that in Nigeria, we have a unique disposition. The question always arises with public appointments, and it is the same for judges as well. Where do you come from? When we say where do you come from, we mean which states in Nigeria. Nigeria has 36 states and the Federal Capital Territory. And in our constitution, it provides that we must look at the issue of federal character. So when you are appointing judges, it's not enough to look at, are they qualified? Do they meet the minimum standards? You also need to look at whether there are many judges from that state already in a position. So for example, Supreme Court, you need 15 judges. We have 36 states. So you could be the most qualified judge. But if there's already a judge on the Supreme Court from your state, you are not likely to be appointed in that position. Because federal character looks at the composition of the government of the federation and any of its agencies, and this includes the judiciary, and that they must reflect and promote national unity and command national loyalty, thereby ensuring that there shall be no predominance of persons from a few states or from a few ethnic or other sectional groups in the government or in any of its agencies. So it's a constitutional requirement. However, this has led to a situation whereby it's not always the best candidate that gets in, but rather those whose states have not been properly represented within that particular agency. There's a double jeopardy for married women. So as a female judge, there's always that decision whether to use your state of origin, where you come from, or the state of origin of your partner. And a case that comes to light is the most recent case involving the current Chief Justice of Cross River State. She comes from, a state of origin is Akwa Ibom State, a neighboring state to Cross River State, but she's married to someone from Cross River State. She's spent her entire career in Cross River State. When she was to be appointed the chief judge of the state, there was a lot of opposition because she's not from that state. So you find that if in selecting judges, you're not only looking at, are they qualified? You're not looking at their experience. You're looking at also where they come from. Then it means that even in terms of allegiance to the issues that they need to be dealing with, there will be other considerations these judges will have to carry on board when making decisions. And the other issue that I wanted to flag is, who do you know? So basically, your political affiliation and family connections. These issues also play a role in determining whether, as a judge, you get access to promotion, you are appointed to very suitable positions, whether in the country or outside the country. And in effect, has also undermined the judiciary, because if you are appointed as a result of your connections and your connections ask a favor of you, it will be extremely difficult for you to refuse them because they are the ones that made it possible for you to get into that position. The issue of financial autonomy had been raised earlier, but I just wanted to mention that it provides an opportunity for us, because if the judiciary fail to have access to their resources and have to rely on the executives in Nigeria, whether it's the state governors or the president in the case of the federal institutions, in order for you to access funding that you need to carry out your job, then this has a lot to play in terms of the delivery, but also the security of tenure that judges actually need in order to succeed in their role. I would like to end with a quote from Audre Lorde, which is that my silences had not protected me, and your silence will not protect you. I think the time is now for us to really raise the bar on the issue of judicial independence and save the judiciary from the state capture that we are seeing happening in our countries and in the continent as a whole. Thank you very much.
Merci. Merci Ozaï pour cette intervention. Et donc, merci beaucoup aussi pour l'appel que vous avez bien voulu faire. J'adhère tout à fait. Il faut qu'on brise ce silence, effectivement, pour parer à la dépendance du système judiciaire, de la profession juridique, donc par rapport au pouvoir exécutif. Vous avez bien voulu nous évoquer le cas du Niger, mais il y a bien donc cette dépendance du système judiciaire et qui impacte effectivement la profession juridique, n'est pas seulement en Nigeria, mais également dans beaucoup de pays. Je vois donc il y a une question qui a été évoquée par un cas concret, effectivement, mais je reviens à cette question. Un des participants demande un commentaire par rapport à la dissolution du barreau du Soudan. Il s'agit de l'ex-président du barreau du Soudan, M. Osman Sherif, qui a posé cette question. Il demande parce que là, il s'agit d'une immixtion du pouvoir exécutif dans un corps qui est censé être libéral et indépendant, qui est le corps des avocats. Alors, avant de répondre à cette question, vous invitez bien sûr vous tous à répondre à cette question. Ou si vous avez des commentaires là-dessus, j'aimerais bien passer la parole à l'honorable Yvonne Dosab, ministre de la Justice de la République de Namibie, pour nous donner son point de vue sur la capture judiciaire et la persécution de l'organisme civique. Est-ce que vous m'entendez?
Yes, Madam Moderator, we can hear you.
Okay,
Unfortunately, the next panelist, the Honorable Ms. Yvonne Dosab, who's Minister of Justice of the Republic of Namibia, has not joined us yet. She's supposed to join us any minute. She was just setting up, but she hasn't joined us yet. So I would say perhaps in order not to lose any more time, we just take, if there's one or two people whose hands are up, they can make short interventions. Then we move to the second session, and then we can take these other panelists in the second session if they join us on time. Thank you, Madam Moderator. So if there's any participant maybe who has a question or a comment, they can be allowed to make short interventions, and then we move to the second session so that we do not lose time. Thank you.
Alors, je dois alors céder la parole à la présidente de la deuxième session dans ces conditions, Donald.
Yes, I think you can do so.
No, don't. Yvonne just
Ok, d'accord.
Yvonne just joined. Try to see if she can intervene.
Yeah, I would suggest that we give her a moment to at least catch her breath and get the feeling of the meeting. So maybe our second session moderator can take over, and after some introductions, then maybe you can invite the Honorable Ms. Yvonne Dosab to make her intervention.
De la deuxième session. Oui, ok.
Thank you very much. I think we therefore hand over now to Ms. Rosalind Hansi, who will moderate the second session. Ms. Hansi, I think, introduced herself before, but just in case some of the participants had not joined, Ms. Hansi is Executive Director of the Zimbabwe Lawyers for Human Rights, one of our most dynamic law-based civil society organizations in the continent and especially in Southern Africa. She's also the chairperson of the steering committee of the African Court Coalition. Welcome, Rosalind.
Thank you. Afternoon, morning, and evening to all our participants participating from around the world. Welcome to this session. So we are going to be expecting to have presentations from some of the following speakers this afternoon. We are going to have a session on the presentation on defending judicial independence in the legal profession in Africa, regional and national perspectives. And this should be shared by Honorable Justice Willie Mutunga, the former Chief Justice from Kenya. And we are also expecting to have a presentation from Dr. Jafed Biegon, who is going to be presenting on what's at stake when judicial independence and the independence of the legal profession is threatened. This is going to be followed by an interactive session that is going to be moderated by Chidio Dunkalu, where we will then discuss developing strategies to enhance judicial independence and the independence of the legal profession in the context of democratic recession. But I do believe that we have got one of the presenters who is waiting to join us online. Dawn, can you just check if she's ready now so that we can give her the floor?
Okay. I think I would agree with that, that we start with the Honorable Ms. Yvonne Dosab. I can see she's online now. So maybe we start with her and then we go to Mr. Nuhu Jalo and Dr. Willie Mutunga.
Thank you.
So Honorable Ms. Yvonne Dosab, you have the floor.
Thank you very much, Don, and everyone else on the panel. I appreciate the opportunity. Just want to check in whether everybody can hear me clearly, John.
Yes, we can.
Okay, very well. Don, I want to maybe start off my intervention with a key question around what has triggered the question around, firstly, judicial independence, whether or not it's under threat, but also why we are talking about, the judiciary being captured. There's been a lot of, at least in my view, and particularly in the Namibian context, I find that there's been a lot of reference to, not only state capture, something that we have experienced, at least in the South African context, but also there's been increasing calls that judicial, independence is under threat. So I want to speak a little bit from the Namibian context, and I know that I only have 7 minutes, and so you can't really go into an academic or scholarly conception of what that looks like. But I thought it would be important to understand, at least as a start, what is the definitional framework when we talk about judicial capture. And it would seem to me it has to do with the fact that judicial capture happens when the safeguards that we have put in place have been compromised, and a number of things happens when safeguards have been compromised. And I think maybe that's where the discussion should start. So the first thing that I find is there is the practical aspects of what is judicial capture, but there's also perceptions. And the perceptions have to do with the fact that when people don't see the kinds of outcomes that they want, when people lose a case, for example, there's always the allegation that either the judiciary has been captured or, our judges are not as independent as they should be. And I say this, I say deliberately that it's a perception because when one calls for factual evidence that either the judiciary has been captured as a collective or that individual judges find themselves in a situation where they have been compromised. I cannot say that about the Namibian judiciary. I have no impression that the Namibian judiciary, for example, has been captured. I understand that the safeguards that are in place. The first one is, of course, our constitutional imperatives, and our constitutional imperatives are set out in the provisions of the Namibian constitution that deals with two key things. The first thing that it deals with, Don and Chairperson, is it deals with the fact that the executive and everyone else in the country is expected to support the work of the Namibian judiciary, and supporting the work is not only anchored on the aspect of a separation of powers, but it's also what kind of resource support we provide for the judiciary to be able to function independently. One of the things that we did in Namibia, apart from the fact that the constitution is quite clear, in its initial provisions, Article 1 and so forth, where separation of powers is clearly entrenched in the provisions of the Namibian constitution, is the fact that we then also kind of extricated, if you'd like. In 2015, the judiciary was extricated from, for example, the Ministry of Justice in terms of the administrative and financial support that the ministry was providing. So under an act of parliament called the Judiciary Act of 2015, the judiciary's independence was then buttressed with an enabling statute. So that was the first thing. One of the later things that we did in the past 10 years or so. But the more 5 years or so. But the more important thing, Don and Chairperson, if you'd like, that has happened with us is the fact that we have what we consider a fairly functional Judicial Service Commission, which has the kinds of stakeholders that you would want to have on an institution like that. Also established by an act of parliament, but also consisting of members of the independent legal profession, and of course also Chief Justice, the Attorney General, and so forth. So you have at least 2-3 members of the Judicial Service Commission that are members of the independent legal profession. So for me, what I find, apart from the constitutional imperatives, is the fact that you then have enabling legislation that helps with providing that kind of safeguard. But the material support that you provide to an office of the judiciary, which is what we now have, independently run, and the Chief Justice is the head of that institution, and they manage how the access to justice kinds of imperatives are managed, whether it's access to courts, whether it's access to legal representation, whether it's access to the independent and objective and impartial management of the judicial service in the country is managed by that institution called the Office of the Judiciary. So there is a very clear line of separation of powers between the executive, the legislature, and the judiciary as the 3 key organs of state. Now, what we have done is also to ensure, because once you talk about an independent judiciary and you're talking about an independent set of judges, in other words, both as a collective but also individually, you need to ensure that there are a number of things that you do. Among them is what kind of security of tenure do you provide for your judges? What is the kinds of reasons that you would want for judges to be removed, for example? It's extremely difficult in Namibia, for example, to remove a judge. Even if there's an allegation of misconduct, there has to be a very objective process that is followed in order for a judge to be removed. We had one case that took a couple of years in the country that involved a senior judge that had to be removed because of certain allegations that were made. So the process, I think, is in that sense above board. I can also tell you, as a matter of course, when there were, and this is the other challenge that we often have, is public opinion and public perception about the independence and impartiality of our judiciary, but also whether or not our judicial system is of such a nature that people have trust that it is doing what it needs to do in terms of justice, and in terms of justice, because it affects people's perception, but also it affects people's trust in the processes and in the institution of the judiciary. So what we have seen is last year when we had our national elections, there was a court case that went to this, that was considered by the Supreme Court. And when the public had already in their mind made up their mind about what the outcome should be of that decision of the court, and if they're not satisfied with the outcome and they don't agree with the outcome, there's often the allegation that the judiciary has been captured. So for me, I want to pause and think for a minute about what are the reasons why people would want to think about the capture of the judiciary, but also what is the relationship between the independence of the judiciary and, for example, public opinion, public perception, but also how civil society engages with the issues that would otherwise lead to what people consider to be judicial capture. So I think in the Namibian context, I want to make it clear, and now, of course, I'm speaking as a member of the executive. We have, over the years, jurisprudence that has developed in the country that has shown the independence of our judiciary, but also to a large extent, the competence of our judges. But what we've not seen enough, at least in my view, and this is a view I hold not necessarily as a member of the executive, but as a legal scholar that understands that when you talk about the independence of the judiciary, it also has to do, to a large extent, it has to do with what kinds of judgments do our courts produce? You know, how do those judgments that our courts produce, but also the jurisprudence that develops over the years, how does it impact on the lives of our people? How does not only the law, but how does judicial activism contribute to enhancing social justice, for example? So we need to really think about judicial independence in the context of where our judgments are taking our society. How are our judgments redefining and reimagining, for example, an inclusive future for our people? So when you talk about judicial independence, it's not a mechanical question. It's not a hypothesis that is simply based on the fact that we think if the outcomes of the judgments don't favor us, either as individuals or as a member or as members of the societal collective, if it doesn't favor us, it therefore means that the judiciary has been captured. So I think people need to be careful about, you know, the allegation of capture because
watching us. Hey, what have you had? Oh, hello, sweetie. That's Mama is sad. That's sad.
Rosalind, I'm not sure what's happening.
Sorry, Honorable Minister, can all the participants please just mute their mics, please? The Honorable Minister is still presenting. Please, s'il vous plaît.
Thank you. I see comments in the chat that indicate that people cannot hear me. Is that the case?
Well, I can hear you from Harare. I'm not sure about my other colleagues.
Okay, can people maybe just indicate whether they are hearing me or not?
I think, Honorable Minister, most of us are hearing you.
Okay.
One or two people might have a problem. Maybe when they were listening to the French, they muted the original audio, so they should just unmute it now. I've tried to advise them that on the chat, so just go right ahead.
Very well. So we need to be sure about why we make the allegation of judicial capture, because I think it's an important one. And I'm not in any way suggesting that it doesn't happen. I do think, you know, where there is credible evidence that you know, either individual members of our judiciary has been captured or the collective is acting in a manner that is not what we would have wanted to see for such an important state organ. So, and I think we need to interrogate that question around the role even of the legal profession in either contributing to these perceptions or being participants in any way, you know, in wanting to let judges and the judiciary succumb to the pressures in some instances of public opinion. And public opinion is starting to play quite an important role in contributing to that perception that our judges and our judiciary is not independent. So I want to kind of move towards the point that we need to, there's a number of factors, and I'm not going to go into the details of what those factors are. I think many of us are familiar with them, about what is it that we need to do to ensure that our judges don't compromise their competence. I mean, one of the factors that contributes to a potential compromise, not of, and it doesn't suggest that there is capture, it just suggests that you compromise quality of the kinds of judgments that comes out of a court. If, for example, a court roll is overdrawn and there is a backlog that judges cannot handle, for example, that may potentially impact on the kinds of the quality of judgments that we see from our courts. The other factors, of course, is the fact that we may have to think carefully about what is the extent to which we want to protect our judges from having to succumb to the pressure of industry and of sector, because sometimes industries and sectors, because they want to see a certain direction, a sector taking a certain direction in our society, may influence individual members of our judges. So you don't want our judges to feel that they need, they have lack in material sense, so you want to ensure that your judges are well taken care of, and one of the sure ways of taking care of your judges is to secure their tenure. In the Namibian context, judges have a retirement age, for instance, and unless there is a question around misconduct and what have you, they are secure in that sense, and they don't have to worry, that if I am depending on the renewal of my contract, I have to satisfy, the appointing authority, the executive, and those kinds of things. So we need to take care of the judges, both collectively and also individually in the material sense as well. Don, I want to, because I know that there are other speakers, and I may want to do an intervention when there's a discussion, but I do want to make two more points, and that is that we need to understand that increasingly, and I've seen it in the Namibian context, I've seen it with the election case in the Supreme Court, is that we've had situations where members of our public, for actual or perceptual reasons, call for judges, and that kind of public pressure, of what kind of outcome judges should see, has become a trend, I think in part also in the Namibian context. And I think that is where you have maybe not judicial capture in that sense, but you do have public pressure on the judiciary to deliver certain kinds of judgments that may or may not influence the direction our societies take. So when we interrogate judicial capture, when we interrogate the role of our civil society in influencing public opinion, we need to be careful about who is capturing who and who is contributing in enhancing the kind of capture that people allege our judicial systems have been subjected to. I want to pause here, Dawn, if I may, and allow other speakers to make their interventions. I'm not sure what the structure of the conversation is going to be in terms of questions and discussions, but maybe at that point I could elaborate a little bit more about the broad issue that I was raising in my intervention. Thank you very much.
Thank you, Honorable Minister Yvonne Dusab from Namibia, giving us those important lessons and also highlights in terms of the Namibian case study on how you have ensured that the independence of the judiciary is actually protected in the Constitution, and how there are other resources that are being provided to ensure that the institutional independence and also the individual independence of the judges in Namibia is protected and safeguarded. You do leave us with important issues that we need to reflect on. including for us to remember that as the legal profession, we do have an important role to play in terms of ensuring that we do not contribute to the perceptions around judicial capture, and that public opinion can actually be very dangerous. But also we need to reflect on who is capturing who as we continue with this discussion. I would want to invite, without much further ado, the next presenter, the Honorable Judge Justice Willie Mutunga, the former Chief Justice of the Republic of Kenya. He is going to be giving us a presentation on defending judicial independence in the legal profession in Africa, regional, international perspectives. Honorable former Chief Justice Judge Willie Mutunga, please, if you can join the discussion.
I'm sorry, Madam Chair. Justice Mutunga was facing internet challenges this afternoon because there's power cuts in sections of Nairobi, but he had sent his talking points in advance and requested that Mr. Martin Masiga, Secretary General of the African Judges and Jurists Forum, should read them out for him, should he be unable to join us. So I think I'd just like to invite Mr. Masiga to take the floor now. He already has the talking points from Honorable Justice, Chief Justice Willie Mutunga.
Thank you, Don. Mr. Masiga, please, if you can take the floor. Thank you.
The presentation by Justice Mutunga is entitled Insidious Pressures to Judicial Independence. And the judge says, traditional pressures, influences, intimidation, and compromises to judicial independence have been seen to come out of the doctrine of separation of powers, the three arms of the state that are supposed to be independent of each other. Over time, other categories such as corporate interests have been seen to be part of the pressures to judicial independence. I did not personally face these pressures, but I was aware that they existed. I want to reflect on my personal experience when I served as Chief Justice and President of the Supreme Court of the Republic of Kenya on these pressures, particularly the insidious ones that we rarely discuss. The first two categories are the only ones that I personally faced during my tenure. One, civil society. With deep roots in organized civil society in Kenya and seeking its help when I was appointed, I realized that a sector organized civil society that I had worked closely with was convinced that they had captured one arm of government, and consequently, I was expected to be cognizant of that fact. I became aware of this pressure when the six of us ruled against the petitioner in 2013 in the 2013 presidential petition. The organized civil society, particularly its intellectual and human rights sector, believed that CORD was the lesser evil of the baronial factions in Kenya. I was seen as a betrayer and was avoided by quite a number of comrades I had been in the trenches with. Two, ethnic community. I faced serious pressure from my Kamba community. Self-appointed individuals paid me numerous courtesy calls to protest the judicial policy of building courts in what they called far-flung areas in Kenya, the marginalized areas where access to justice was non-existent. In my own county, the court there was to have an extra floor built to accommodate its status of a high court. The judiciary did not have land. Part of the land set aside for the judiciary had been grabbed. This reconstruction was the only option. In a ceremony to start the reconstruction, I was reminded by politicians who had been in government for over 3 decades that my county needed a huge building if I was going to have a meaningful legacy. I decided to address the Wananchi directly, gathered there, rather than self-serving politicians. I convinced them that the far-flung compatriots needed courts too, that the decisions on building courts had been made before I became Chief Justice, and I had to implement them. I told them that it would be corrupt to move resources from these far-flung areas to my county. I urged them to use the traditional justice system to sort out their disputes. I told them of our policy on mobile courts that would make sure judicial officers would come to them and save them transport costs to the courts. My best argument was the last. It was that in any event, there was no land for such expansion, and that the Wananchi would ask the governor and should ask the governor and accompanying politicians to donate land for such building in the future. This encounter with my people taught me a lot about judicial politics. I continued to receive pork barrel courtesy calls from my people until I realized that I had given them enough tea in my chambers and dismissed them. They were bold enough to tell me that if I ever got into trouble, I should never go to them. My reply was equally dismissive. I told them I would go to the communities I was building courts in, and they would get me out of trouble. The other source is family, relatives, and friends, the source of pressure. Judicial officers have to police family, relatives, and friends who could easily take bribes claiming they would put in a good word for the litigants to the judicial officers. I knew of incorruptible colleagues who got into trouble out of pillow talks or by self-appointed agents from family, relatives, or friends. Religion. Once, my Muslim brothers, no sisters were involved, offered to help me when the judiciary had a dispute with the executive and parliament. They wanted to support me through demonstrations targeted at the enemies. I had to convince them that it was a bad idea. The enemies would think I organized the demos, and we would all face the imperial and parliamentary music. Luckily, they agreed with me. The other is judicial officers. A lot of work needs to be done on how judicial officers are an insidious pressure against judicial independence. We know of chief justices giving instructions on behalf of cartels, politicians, and other interests. Other judicial officers routinely do this by invoking ethnicity, religion, region, clan, gender, generation, and divisive social media groups to subvert judicial independence. Some judicial officers who may be connected to the powers that be do intimidate colleagues during conferencing. These insidious pressures are more destructive than the external ones because they are termites within, destroying the independence of the institution and the decisional independence of judicial officers. The international community. A euphemism for foreign interests can also be a source of pressure. Donors and institutional collaborators have their interests too. My experience was that these interests are not as crude as the activities of parliament and executive. Threats to deny the judicial resources that are people's, and the other threats to judicial independence, but are dangerous just as well. Law clerks, secretaries, security detail can also be a source of pressure. Law clerks can impact decision independence of judicial officers negatively, particularly when they are convinced they are researchers for judicial officers who are intellectually lazy. How often did we hear in the grapevine that some clerks were bragging they had penned a landmark judgment? Judicial officers should also be wary of secretaries and security detail who suddenly want to talk of cases that are being heard. The bar. The bar has a long history of the formation of serious cartels that enslave judicial officers and subvert independence of the judiciary. I remember when I was president of the Law Society of Kenya, there was a permanent item in the agenda on this issue. At that time, familiarity with the judicial officers was pegged on racial and ethnic considerations in the judiciary. Conclusion. Judicial independence must depend on the integrity of judicial officers. They must never think of taking a bribe. They must be aware of all these pressures and confront them successfully. The institution of the judiciary itself cannot afford divisions within it if it is serious about its independence. Thank you.
Thank you, Mr. Masiga, for sharing the thoughts from Honorable Justice William Mutunga. A very rich paper that you have presented there, where he's sharing with us the different sources of threats to judicial independence, both at the institutional and also at the individual level. Very important insights there from his own experiences, and also possibly how, when faced with such threats, the judicial officers can be able to react and respond to those threats, which are very diverse and sometimes can be very persistent. And maybe also just his thoughts around the use of the more modern media platforms like social media, which will leave us a lot to discuss during the discussion session when we do the strategies. So without wasting more time, as I think we are running low on time now, I would want to invite the next presenter, who is Miss Muya Nyaundi. She's now presenting just before Dr. Japheth. And she's a senior staff attorney at the American Bar Association Center for Human Rights. She's focusing on sub-Saharan Africa. She's going to be sharing with us her thoughts on the subject at hand. So I would want to welcome Muya. Please, if you can take the floor.
Thank you, Rosalind, and thank you to the African Court Coalition and the Pan-African Lawyers Union for organizing this panel. I've been asked to speak on what is at stake when the independence of the legal profession is threatened. And I'll start by just explaining, very briefly, because we might have non-lawyers amongst us, what we mean by the independence of the legal profession. It's very basic, the ability of members of the profession to carry out their professional duties without outside influence, without coercion or pressure from external factors. And when we talk of the independence of the legal profession, the UN basic principles have set out certain principles that protect the independence of the legal profession. I've chosen 4 principles really quickly. Lawyers must not be associated with their clients' causes. They must not face retaliation for their professional duties. Like other citizens, they should be entitled to exercise freedom of expression, association, assembly without suffering professional restrictions. And then finally, self-regulation of the bar of the legal profession. While the best practice is that lawyers should be able to self-regulate themselves without interference from the executive. This is the ability to determine who can be a member and who can be disciplined for the rules of conduct and who can be disciplined from his conduct. So, so that there's no doubt as to whether the legal profession in the region is under threat. Unlike organizations which follow press freedom, the freedom of the press, they can tell you, at the end of the year, 300 journalists were arrested, 300 journalists are in detention, or certain journalists have been killed or disappeared. Unfortunately, we don't have those statistics amongst the legal profession, but this is not to say that the legal profession is not under threat. We are members of the legal profession, and we have heard and responded to reports of members of the legal profession across the region under threat. And I'll give them a few examples for those who may not be non-lawyers and may have not followed these incidences. In Ethiopia, lawyers, particularly those representing political cases, especially after the current unrest in the north, they've been accused of They've also been accused of being part or sympathizing with the armed groups. They've faced death threats. They've been arbitrarily detained and harassed. In Zimbabwe, lawyers also representing political clients have been harassed during the course of their jobs. Government officials have also told the Law Society of Zimbabwe to stay in its lane when it has commented on issues relating to the amendment of the constitution. We also heard of a case of Beatrice Mteto, who was barred from representing her client by a magistrate court. Again, in Tanzania, we have a case of a human rights lawyer who was permanently disbarred in retaliation for instituting a case against the president for appointing the attorney general. Sorry. In Tanzania, there's a case of a prominent human rights lawyer who was permanently disbarred in relation for her litigating a case in which she challenged the appointment of the attorney general. We know that 2 other lawyers in Tanzania are currently facing disciplinary proceedings for their, commenting on matters of public interest on social media. Most recently, lawyers across the region rallied in support of several lawyers, including Nicholas Opiyo in Uganda, where the view is that these lawyers were arrested in retaliation or a crackdown on civic space ahead of the elections. There are so many other cases across the region that I can comment on. We have DRC, Cameroon, Madagascar, Angola, and Mozambique of lawyers who have been attacked and are facing retaliation for engaging in their professional duties. So the reality of it is that as we note, democracy is in decline across the globe, and especially in Africa, and in light of the COVID pandemic. And from the cases that I have described, we see that the role that lawyers play in representing their clients' rights, as well as holding the government accountable, the 3 arms of government, that's the judiciary, the legislature, and the executive. And because lawyers stand in between, we tend to be victims. And I will quote a line by Shakespeare, which says that first we kill the lawyers. So generally, explaining this, it's basically when governments are trying to restrict fundamental freedoms, in order to do that, they will first attack those that stand in the way. And in several of these countries where governments are clamping down on civic space, being a lawyer has become an extreme sport. It's actually dangerous, a hazardous occupation to be a lawyer in certain countries across the region. So what is at stake when we talk of lawyers, the independence of the legal profession, and lawyers not being able to robustly defend their clients or robustly engage in matters of public interest? In many of the countries that have given examples of where the independence of the legal profession is under threat, lawyers are now afraid to take on sensitive cases or hot cases. This means that the access to justice for certain citizens is undermined, as well as the equality of arms, which is especially important in criminal cases. You also find that in certain countries, there are a few brave lawyers, meaning that these are the same lawyers that are constantly representing certain cases. And because of that, they have a heavy workload, which, even though they're trying their best, they're not able to then robustly represent their clients. The quality of legal services is undermined. And in some instances, I've found that those few lawyers that are there, because it's a hazardous occupation, they charge exorbitant costs or exorbitant fees in representing their clients, making legal representation inaccessible to many. And then in other countries where lawyers have taken up sensitive cases, they don't robustly engage on behalf of their clients, choosing less adversarial approaches, which may not necessarily be in the best interest of the client. And then, of course, we have instances where bar associations have been undermined. They're not able to robustly cater for to protect the rights of their membership, as well as play their role in which they hold the government accountable as a collective. Lawyers, bar associations tend to lead in ensuring that the development of the law. We are a society that is governed by rules and regulations, and lawyers, bar associations play a fundamental role in the system, in the establishment of rule of law and holding the government accountable. So when bar associations, the independence of bar associations is undermined, that role is also undermined. The COVID pandemic, I think for many of us, was a reminder of the importance of a robust legal profession. When national emergencies occur, people tend to panic. The state panics, everybody panics, and we saw an enactment of many pieces of legislation meant to ensure public safety and security. And hence, at times, rule of law is undermined, and the judiciary, executive, legislature, and even the public is complicit in the undermining of these laws because of the state of emergency. And we also saw this after the 9/11 attacks. So the legal profession is extremely important in safeguarding the rule of law, especially where popular opinion is not holding the government accountable. The last points that I would like to make on what exactly is at stake when the legal profession is undermined. When lawyers are not able to robustly defend clients, and I'll probably take an example of terrorists or people who are accused of terrorism and are in detention. And I use this example because we know that terrorist activities all across on the continent is on the rise. Or even in election situations, the trust in the judicial system is undermined. As I said, the equality of arms is undermined because lawyers are not able to robustly undertake these their roles. So because of the undermining of the legal justice system and the rule of law, citizens tend no longer to trust the justice system, no longer to trust the government that is in place. And that leads them to seeking other means of redress. And in the end, that can lead to chaos and instability. We just have to look at the continent and the number of conflicts that are ongoing at the moment, primarily because citizens have lost their faith and trust in the rule of law. And then the final point I wanted to make is that a lot of times in many of the countries on the continent, there's now been a divide between human rights lawyers and, let's say, commercial lawyers. And when human rights lawyers have been attacked, commercial lawyers tend to put their head down and say, well, it's got nothing to do with us. They are, speaking up and getting themselves into hot water. But the reality of it is that autocratic regimes practice oppression and restriction on minority groups, and they finesse these tools, and then inevitably they'll use these tools on the entire population. It does not just end with a few individuals. So it must be of concern when members of the legal profession are facing attack, when the independence of the legal profession is attacked, to all lawyers. Rule of law is fundamentally important, especially on the African continent. We know that the rule of law is directly related to development, to economic and social prosperity, and hence, by virtue of this, it's fundamentally important that all lawyers take an interest, regardless of whether you have political interest or engage in public. You should take an interest and be concerned when the independence of the legal profession is threatened. I will, as lawyers, this is what we do. We end with quotes, and I will end with a quote with Australian Judge Justice Kirby, who emphasized the importance of the independence of the legal profession. And he says, where there is no independent legal profession, there can be no independent judiciary, no rule of law, no justice, no democracy, and no freedom. I end there. Thanks, Rose.
Thank you, Moya. You really explained the role of lawyers as provided by the basic principles of the United Nations. And you also shared examples of instances where lawyers have been attacked across the continent, but also the challenges that we have, including the fact that we don't have consolidated statistics on these attacks, but also the challenges that bar associations are facing. And without wasting any more time, as we are running out of time, I would really want to apologize to Mr. Nuhu Jallo that I pulled in honor ladies on him by asking Ms. Muya to start first. He was in fact supposed to start before the Honorable Justice Willie Mutunga. Mr. Jallo, he's the Deputy Registrar of the African Court on Human and People's Rights, and he's going to be presenting on defending judicial independence and the legal profession in Africa. regional and national perspectives. Please, Mr. Diallo, if you can go ahead.
Merci beaucoup, chers participants. Je m'excuse parce qu'à un moment donné, on s'était coupé. Et par ailleurs, je suis dans 2 réunions parce qu'actuellement la Cour est en session, donc j'étais obligé de faire des va-et-vient. Donc je m'excuse beaucoup pour ça. Je ne vais pas prendre beaucoup de temps. Je voudrais juste partager avec vous l'expérience de la jurisprudence de la Cour en matière d'indépendance de la justice. Comme vous le savez, la Cour applique la charte et le protocole. La charte et le protocole, surtout la charte en article 26, invite les États, oblige les États à veiller à l'indépendance du système judiciaire. Donc, en quelque sorte, la Cour, quand la Cour reçoit des affaires qui portent sur des questions qui portent sur l'indépendance de la justice, la Cour se prononce. Alors, donc, je vais partager avec vous deux cas dans lesquels la Cour s'est prononcée. D'abord, au tout début des premières ordonnances de la Cour a rendu une ordonnance le 10 août 2015 dans une affaire Saïf el-Islam Kadhafi, le fils de l'ancien président libyen, contre la Libye. Et Saïf était arrêté et poursuivi. Il y avait un risque qu'il soit condamné à mort. Donc, la Cour avait issu une ordonnance de mesure provisoire instruisant la Libye de s'assurer que Saïf el-Islam soit jugé avec un système judiciaire indépendant. Donc, cela a été fait. D'ailleurs, je parle sous le contrôle de l'honorable Souhaite Amègre qui était à la commission parce que l'affaire a été soumise à la Cour par la commission. Ensuite, dans une affaire beaucoup plus récente qui a été rendue en 2019, l'affaire Sébastien Adjavon contre la République du Bénin, le requérant a soumis à la Cour et se plaignait de 2 points essentiels. D'abord, le manque d'indépendance de la Cour constitutionnelle et deuxièmement, le manque d'indépendance du pouvoir judiciaire. Donc, c'était les 2 points sur lesquels M. Adjavon se plaignait au niveau de la Cour. Donc, la Cour a examiné l'arrêt et la Cour a estimé qu'il y avait 2 aspects en fait. L'aspect personnel et individuel et institutionnel. Sur l'aspect institutionnel, la Cour a estimé qu'il n'y avait pas de preuve que la Cour constitutionnelle dépendait ou bien recevait des ordres d'une quelqu'un d'autre institution. Mais l'aspect individuel, là, c'est plus intéressant, parce que l'aspect individuel, la Cour a examiné, et la Cour a constaté, selon une nouvelle loi qui modifie la Constitution du Bénin, la composition de la Cour constitutionnelle du Bénin, à part les magistrats, on avait, à part le président de la République qui est président du Conseil supérieur de la magistrature, vous avez également des membres qui ne sont pas des magistrats, donc qui sont nommés par le gouvernement. Et l'un des points intéressants également, c'est qu'il est écrit que la Cour constitutionnelle donne des avis au gouvernement. Donc, pour ce qui est de l'indépendance du Conseil supérieur de la magistrature, on a constaté qu'à part le président de la République, il y avait le ministre de la fonction publique qui faisait partie, le ministre des Finances qui fait partie et le ministre de la Justice qui fait partie. Donc, la Cour avait estimé que, du point de vue composition du Conseil supérieur de la magistrature, le Conseil n'était pas indépendant vis-à-vis du pouvoir judiciaire. C'est cet aspect-là que la Cour a souligné. Également, le Conseil supérieur de la magistrature qui gère la carrière des avocats. Alors qu'il est évident que le Conseil supérieur de la magistrature dépend directement du pouvoir exécutif. Donc, la Cour avait estimé que, effectivement, dans ces conditions, il ne peut pas y avoir indépendance du pouvoir judiciaire et a demandé à l'État du Bénin de revoir sa copie, de modifier la loi pour revoir la composition du Conseil supérieur de la magistrature. Donc, voilà un exemple concret, parce qu'effectivement, si c'est d'ailleurs quelque chose qui a déjà été dit par les intervenants premiers, si effectivement la carrière des magistrats est gérée par le pouvoir exécutif, il est difficile d'avoir une justice indépendante, ce qui effectivement pose problème. Mais au-delà de cet aspect, je pense que il faut aussi quand même souligner, parce que maintenant, quand vous regardez dans beaucoup de pays, on met en place un conseil supérieur de la magistrature dans lequel il n'y a pas le gouvernement. Mais il faut aussi souvent que les juges assument leur indépendance. Ils peuvent juste assumer leur indépendance. Il y a cet aspect. Il y a aussi l'aspect de la formation. C'est très important. Très important que les juges, aussi bien les juges que les avocats. Et comme a dit l'honorable Soyata, la fonction des avocats et celui des juges, les deux sont liés. Les deux ne sont pas différents parce que l'indépendance de la justice ne peut pas être effective sans qu'il y ait un barreau qui soit bien organisé, où des avocats sont bien formés, où ils sont également indépendants. Donc les deux, à notre avis, ce sont les. Effectivement, les solutions, il y en a, tout le monde en a parlé. Il faut un état de droit, il faut qu'il y ait de la volonté politique. Ce que nous avons constaté ici à la Cour, c'est que très souvent, dans beaucoup d'affaires, c'est ce manque de volonté politique des dirigeants qui ne veulent pas changer les choses, qui ne veulent pas avoir vraiment un système judiciaire qui soit indépendant. Mais il y a aussi l'éthique, où ça concerne aussi bien les magistrats que les avocats. Et moi, je sais que cette année, dans mon pays, le Burkina Faso, nous avons eu l'exemple d'un magistrat qui était envoyé en prison. Pour qu'un magistrat soit envoyé en prison, c'est que c'est vraiment grave, c'est qu'il a été pris en flagrant délit de corruption, avec vraiment des faits tellement flagrants que ses collègues n'avaient pas d'autre choix que de l'envoyer en prison. Donc ça, c'est un exemple concret qu'il faut également que les gens se comportent de manière à respecter l'éthique. Effectivement, mais ça aussi, ça dépend des conditions de travail des magistrats et des avocats, la condition de rémunération des avocats et ce que effectivement les avocats également gagnent. Donc, je voulais également ajouter qu'ici à la Cour, et je voulais parler de deux points essentiels également. La Cour organise chaque 2 ans ce qu'on appelle le dialogue judiciaire. Le dernier a été tenu en 2019 à Kampala, en Ouganda. Le dialogue judiciaire, c'était institué par l'Union africaine et invite tous les présidents des cours suprêmes, les procureurs, et la société civile, et donc incluant également les avocats, pour discuter ensemble et puis voir comment améliorer le système judiciaire en Afrique, discuter, échanger, voir quels sont les défis du continent en matière judiciaire et proposer des solutions pour aller de l'avant. Dans ces solutions, il y a aussi, on parle également de formation, il y a le cours de formation que nous donnons en ligne, les cours pour les magistrats dans les tribunaux locaux. Donc, et nous avons également une liste des avocats inscrits ici à la Cour. Et chaque année également, nous organisons une formation pour les avocats qui sont inscrits sur la liste des avocats de la Cour. Donc, les avocats viennent de différentes régions du continent qu'on organise chaque année. Donc, voilà à peu près, je voulais juste partager l'expérience de la Cour. C'est pour conclure, je veux dire que, en fait, tout cela, c'est une question de volonté politique des États. Si, par exemple, la Cour, maintenant, il y a des instruments, il y a des textes. Si les États ont la volonté politique de laisser la Cour faire son travail, chaque fois qu'il y aura un dossier porté devant la Cour qui touche l'indépendance du système judiciaire, la Cour va se prononcer. Et s'il y a lieu de condamner, la Cour va condamner. Maintenant, est-ce que les États vont appliquer ou pas? Ça, maintenant, c'est autre chose. Je vous remercie bien et j'espère que je n'ai pas dépassé les 7 minutes. Merci bien.
Thank you very much, Mr. Jallo. You really shared with us some of the experiences that we may not be aware of, especially the jurisprudence that is coming out from the African Court. We really appreciate the insights that you've given us on the decisions that you have made, cases that were brought before Libya and also the Benin state, as well as some of the initiatives that the African Court is taking in terms of ensuring that even the advocates also receive the necessary training to ensure that they continue to maintain their independence, as well as ensuring that judicial independence at the institutional and individual level is also promoted. But you leave us with a reflection in terms of one of the main issues that we continue to face in Africa around the issue of political will for the citizens of Africa, the people living in Africa, to enjoy institutions that are independent, particularly the judiciary. Without wasting any more time, as we are really running out of time, I would want to invite the last but not least speaker, Dr. Japhet Jean. He's the Africa Regional Advocacy Coordinator with Amnesty International. And I'm going to seek indulgence from you participants that we may need to extend this session as we are running out of time, to ensure that we also have time to interact with Chidi Odunkalu on the interactive session on the strategies. Dr. Japhet, please, if you can go ahead.
Thank you so much, Roslyn, for this opportunity. I'm also grateful to the African Court Coalition and the Pan-African Lawyers Union for convening this timely webinar on this important topic. I was asked to speak, like my counterpart, Ms. Muya Nyaundi, to speak on what's at stake when judicial independence and the independence of the legal profession is threatened. Muya has spoken about, has focused on the independence of the legal profession. My part will focus on independence of the judiciary. And I would like to start off by prefacing my remarks on two ongoing current events on two countries on the continent. The first is Kenya, where I'm currently based. The country is currently in the process of recruiting a new Chief Justice following the retirement of Justice David Maraga sometime last month. And after a process of advertisement of the vacancy of the position of Chief Justice, one of the perceptions that has come out, not least within the legal profession, is that the candidates who applied were not only just few, but there is a perception that many qualified, outstanding lawyers and judges and advocates across the country did not apply this position, including all the sitting judges of the Supreme Court of Kenya. And one of the reasons that they are giving for the failure of that vacancy to attract outstanding individuals that we thought to have applied for this position is the threatening of judicial independence in the wake of the Supreme Court invalidating the presidential election way back in 2017. You may remember that after the invalidation of that election, there was threats, both in terms of utterances, but actually actions are taken against judges across the country, culminating in the president refusing to swear in 41 judges for close to a year or more now during as part of that clampdown on the judiciary. So there is a fear that many outstanding candidates will not want to become Chief Justice or join the judiciary because of this threat that has been leveled against the judiciary. The second important development that I would like to use to preface my conversation is that just this Monday, on 22nd of February, President Cyril Ramaphosa of South Africa issued a statement on the dangers of utterances that threaten or undermine the judicial independence. I think it's a rare statement coming as it did from a head of state in an attempt to defend the judiciary and calling out unwarranted attacks on the judiciary. And I found something profound in the statement. He quotes the words of former Chief Justice of South Africa, Sandile Ngcobo. And this is what Sandile Ngcobo said way back in 2010 concerning judicial independence. Without public confidence in the ability of the courts to dispense justice, there can be no faith in the rule of law. Without faith in the rule of law, valuable relationships of trust within society begin to break down. citizens can no longer assure their rights will be respected. Businesses can no longer be assured that their contracts will be honored. Victims of crime can no longer be assured that justice will be served in court. Public confidence is therefore vital. That is why courts must not only be independent and effective, they must also be seen to be independent and effective. I thought to preface my presentation this afternoon with these two developments, because what they tell us is that threats on judicial independence or lack of it in actual sense is not just an academic concept. It's not just an hypothesis. It's not just a concept that is learned in relation to separation of powers and checks and balances in terms of constitutional order. The absence or the presence of judicial independence actually affects real lives. It affects people in very personal, real ways. And I thought, because of time, I'll just focus on two perhaps very extreme cases to illustrate how the lack of independence or threatened judiciaries can lead to very lived realities for people, especially in the context of enjoyment of human rights, which former Chief Justice of South Africa, Sandile Ngobo, did refer to. The first, I would like to use the case of Kenya. You may remember back in 2007, the country was plunged into near collapse, into the brink of conflict because of the post-election violence that ensued following a dispute of the presidential election in Kenya. What is often not talked much about is that the lack of trust and public confidence in the judiciary played a very big part in pushing the country towards the path of violence. Of course, the disputed presidential election triggered the violence, but the losing party, former Prime Minister Raila Odinga, categorically stated that they will not challenge the election results in courts because they had no confidence because of a history of the judiciary siding and being a pendant or an appendage of the executive. They thought that approaching the courts would not yield, will not be of any result at all. And therefore they decided to call for mass protest. And it's in that context that the country was plunged into violence that led to more than 1,000 people dead, women and girls raped, just because of the failure or the lack of trust and public confidence in the independence of the judiciary. For you to appreciate how that factor of judicial independence played a part in this violence that led to many people dying and suffering, you have to fast track events to 2013, when Kenya again held a presidential election. And once again, Raila Odinga lost against Uhuru Kenyatta in this particular case. But this time round, because there were now a reformed judiciary and former Chief Justice Emeritus Willie Mutunga sitting as the Chief Justice, there was confidence in the judiciary that it could offer and be, it could be independent in its determination of the presidential election. And that is how it happened that Raila Odinga went now this time to the court to challenge that election. Of course, he did lose and he accepted that result because of the confidence that he had in the judiciary. So essentially I'm saying, what is at stake when judicial independence is threatened or is actually absent is that the fate of an entire nation can actually be dependent on judicial independence, as we saw in 2007, 2008 in Kenya. The second aspect that I would like to quickly highlight is that election disputes come and go depending on electoral cycles. But questions of judicial independence affect individuals at a personal level and on a daily basis. And here I would like to focus, because of my background, on human rights defenders, as Muya already talked about, and Osayo Ojig already also talked about. But we see where judicial independence is threatened and the judiciary becomes an appendage of the executive, they then become part of the arsenal of repressive and dictatorial states. where judiciaries are used then to harass human rights defenders. And no wonder there is actually in the lingua parlance of human rights defenders, the term judicial harassment, that executives use the courts and the laws to harass human rights defenders. And it is in cases where judges and magistrates are willing to work at the behest of the executive or at the behest of repressive regimes that we found that judicial harassment flourishes. And this affects many human rights defenders who are currently languishing in jails for the work that they do as human rights defenders. We can speak from Jermaine Rukuki in Burundi to many more in Egypt. And just to end, for instance, with perhaps another extreme case of where the lack of judicial independence really reveals what is at stake. We go back to March 2014 in Egypt, a criminal court in an area called Minya. On this day in March of 2014, a criminal court in Egypt sentenced 521 people in a single hearing that very morning to death. And the reason is that these were supporters and were alleged to have engaged in violence, supporters of former President Mohamed Morsi. So in a single swoop, the judiciary, which essentially was not independent, was an appendage of the executive, sentenced 529 people to death in a single hearing. This is perhaps the largest single batch of simultaneous death sentences ever seen anywhere in the world, and it reflects how when the judiciary is not part of the independence, the real lives of human rights defenders, but also the real lives of day-to-day people protesting or demonstrating or seeking justice are vanquished by a court that is not independent. Due to time, Ranzi, I think those two examples will suffice to show what is really at stake when judicial independence is threatened. Thank you, Rose.
Thank you, Dr. Jaffet. You really gave us some of those quite shocking examples, particularly the last example that you gave us on how countries that are lacking judicial independence can actually face more human rights violations than they should be if they had more independent judiciaries. We also thank you for giving us insights into developments in Kenya and also more recently in South Africa. As we continue this discussion, due to the fact that we are running out of time, I'm going to ask the last facilitator who is going to be taking us through the strategies, Chidio Dunkalu, to please start the session. We are also seeking indulgence from those participating from the different parts of the world for us to have an extension of 30 minutes to be able to cover the last session that we have on the program. Please, Chidio Dungalu, you can take over.
I hope I come across clearly enough. Thank you very much, Rose, for having piloted us this far, and to all the colleagues from all over our continent and beyond who've tarried with us, thank you even more. I hope we can at least begin to get some contributions, and I just wanted to provide a roadmap as we do so. I should also acknowledge that because of the work is done, I think I owe it to us to acknowledge that immediate past Chief Justice of Kenya, David Maraga, has spent most of this meeting with us. And Chief Justice Maraga has paid a huge price defending judicial independence in the work that he did. And I think it's appropriate to acknowledge that. We've had a great deal from across our continent, and that's one of the great features of this meeting today. At least 10 or thereabouts African countries have been involved from the north of Africa. Kenya, South Africa, Mali, Senegal, Nigeria, Namibia, Zimbabwe, Benin, I think Tanzania, I could go on. We've heard from with different experiences on these issues. And what's remarkable is that a lot of the experiences appear similar. There are, of course, certain disagreements not disagreements, but nuances. So there are no judicial unions in Anglophone countries, but it looks like there are in Francophone countries. There are countries that offer inspiration, and I'm not at all surprised that in a place like Namibia, my sister Yvonne Dausab is the justice minister and offers us some inspiration in what's possible. Next door, of course, you've got Zimbabwe, which also inspires us in a different direction, which is why people like my sister Rosalind Hanzi are there leading the charge and the fight. And we've got continental institutions which have been led by people like Maître Maïga and Justice Mwepe from South Africa, who have also addressed us much earlier. There are lots of themes that have emerged. I'm not going to try to list all of them, but I want to summarize a few. One is, and also so that we can get into the conversations for about 20, 25 minutes before we conclude. One is the question of institutional design. How do we set up the court systems for independence so that they can resist what Justice Minister Dausab spoke about, and also I thought the fascinating presentation by former Chief Justice of Kenya, Willy Mutunga. The second raised by Ms. Ojigo was financial autonomy. The third, which has emerged from pretty much nearly every presentation here today, is the question of defense of an independent legal profession and how that is intrinsically linked to every conversation about judicial independence. Then there's the controversial subject matter of judicial capture. And I believe in the presentations by Chief Justice Willy Mutunga and Justice Minister Yvonne Dausab, you begin to see that all of us are accused of being competitors in judicial capture. Civil society, to politicians, to business people, to international community, everybody appears to want to capture judges and the judiciary. I thought Justice Minister Dausab made a remarkable point. How do we get a judiciary that produces jurisprudence that can command the confidence of the people and of the communities that the judges serve? And that raises the point about judicial accountability and how that is inherently part of the dialogue on judicial independence. Now, there are a few supplementary directions that have been flagged here, and I'll add three. One is that political support is necessary, and my brother Japhet, I think, introduced that point when he talked about what President Ramaphosa recently did, that we do need politicians who can stand up for the defense of independent institutions. That's one. How do we grow that constituency? The second, which has been made by several people here, Maître Maïga, Justice Mwepe, and Maître Jallo, is the role of regional institutions, including the regional economic communities, the courts and tribunals of Africa and the other regions. And you can see that, for instance, in what the East African Court of Justice did last year when they ruled against the president of Sudan, who had fired a dozen or more judges summarily without recourse to any disciplinary methods, and they ordered the recall of those judges. So what role is there for regional courts and tribunals and regional institutions? The third is the deleterious effect of election petitions. Election petitions have become a huge charge on the credibility of our courts and tribunals across Africa. How do we address that challenge? And then for what we therefore want to address in the next 20 minutes is, what is the role here for advocacy? How do we forge an advocacy agenda, and what should be there? Who do we work with? How do we reinforce one another in the enterprise of trying to defend judicial independence and an independent legal profession across the continent? And the floor should be open. We'll take contributions for not more than 90 minutes. Sorry, 90 seconds. I say minutes. 90 seconds per speaker, please. Not more than 90 seconds. I see that Femi Falana, the former president of the West African Bar Association, has requested to take the floor. And after him, Waikwa Wanyoke, who has experience from 3 continents on these issues, would also offer us some directions. And I hope that others would join. Essentially, we are looking at suggestions now. What can we do? Mr. Falana, please, you've got the floor. 90 seconds. Femi Falana. If Mr. Falana is not coming on immediately, can Mr. Wanyoke please wipe up while Mr. Falana gets ready?
So thanks, Chidi. Very quickly, because it's 90 seconds. Waiko Wanyoke, a lawyer in Kenya, but also litigation director with Open Society Justice Initiative. Numerous times during today's webinar, we can never drop the idea of litigation, even if it is for purposes of just establishing yes, the reason we would litigate even for the record is an experience we went through after the promulgation of the 2010 Constitution in Kenya, where we were, there was a vetting process for judges, and the record of what judges had done in terms of upholding or not upholding judicial independence became key in terms of which judges were selected to go ahead. I have to mention
Sorry. Sorry, Waikwa, you seem to be unstable, your connection.
So, sorry, I think, can you hear me, Chidi?
Yes, we can now.
I'm not sure why I'm going in and out. So I was just talking about litigation, even if it's for the record. But the second point about litigation is on issues of litigation. 2 things I wanted to highlight that may not have been emphasized enough. One, litigating or pursuing advocacy relating to funding of the judiciary and why that is so key. And we're looking at different jurisdictions where we would bring that advocacy or litigation, because that's one way that even when you have legislative or constitutional provisions that are strong on independence, judiciaries get shortchanged, and in fact, their independence get compromised through funding. The last point, so just so that I don't overrun my time, has to do with issues to do with implementation of court judgments. A lot of our jurisdiction, even those which are very, very strong, have very strong constitutions, we are seeing failure by, especially by executive, to abide by the court judgments. This is a significant problem in Kenya, but it's a significant problem elsewhere. I know it has been even in places like South Africa, for example. And in fact, we are running into a situation where that we've seen in other jurisdictions in the world, and just to cite 2 places like Brazil and Colombia, where the situation is so bad in on implementation of judgments that petitions or litigation of unconstitutional affairs. And so
sorry, Waikwa, can you finish, please? Mr. Falana, you'll come after
Yes,
the present speaker.
I'm back now.
Okay, so wait a moment. Let the present speaker finish, and then you come on. Once he finishes, you can start. Thanks.
Thank you very much.
Waikwa, please, can you conclude? Waikwa? Okay, Mr. Falana, please, can you proceed?
Yes, I just wish to say that particularly when we were involved in the struggle against military dictatorship in the various African countries, we rely heavily on the regional courts, particularly the African Commission on Human and People's Rights. It will be important to know what has happened to the commission, because in January 2019, we sent a petition in respect of 51 Cameroonians, refugees and asylum seekers who were illegally deported from Nigeria to the lion's den, as it were. Even despite the fact that we also filed an application for provisional measure, the African Commission refused up to now to entertain the complaint, and because of that, the applicants were jailed by a military tribunal, contrary to an earlier decision of the commission that a military tribunal cannot try civilians. The second one is on the role of Palu. When Tanzania indicated a wish to withdraw the declaration made for the representation of NGOs and individuals in the African court, I did suggest to the Secretariat of Palu, if Article 1 of the African Charter could be invoked by preventing or challenging the move by the leadership in Tanzania to withdraw from the court, because that provision has imposed a duty on all member states to adopt legislative or other measures to give effect to the provisions of the charter. Again, we couldn't get any reply, any positive reply from the African, from the Palu. The point I'm making, therefore, is that yes, it's not the first time that we have found the judiciary in many of our countries to be very weak and ineffective. But we have also had to resort to regional mechanisms in dealing with, the collapse of the rule of law in many of these countries. So my question is, how can we revitalize the African Commission? African Court is being partially, just like the ECOWAS Court. Judgments are given. Again, we have problems of compliance. But can we revive the African Commission? Can we restore the SADC tribunal, and so on and so forth? Thank you very much.
Thanks a lot, Mr. Falana. I see Princess Cecilia Ndifon has her hand up, and then Justice Minister Yvonne Dalsab as well has her hand up. Can we go in that order? 90 seconds. Ms. Ndifon, please. Yvonne, can you help us unmute her?
Oh, my.
Okay. Ms.
Hello, can you hear me?
Yes, indeed, we can.
Can you hear me, sir?
We can hear you. Please proceed.
Okay, so it's a real pleasure for me to join the coalition. Ever since I was admitted as a member, all my mails went to spam. So it's just a few weeks that I came back and got connected to where I belong. So I'm so overjoyed to meet you. And to be very brief and concise, what I would suggest is that we, the legal minds of Africa, let's come together, form a strong advocacy team. Hello, are you getting me? Hello?
We hear you. Please proceed. Continue.
Okay. We come together and form a strong advocacy team, we, the legal minds of Africa, And we must be ready to be fearless, ready to lay down our lives for our continent. And we will have to involve the civil society, the credible civil society organizations that can mobilize the citizens to back up any of our advocacy agenda. So I will end here.
Thank you very much, Madame Difon. Ms. Dausa, please.
Thank you very much, Chidi. And it's wonderful to see you, Chidi. It's been many, many years since I last saw you in Banjul at the African Commission on Human and People's Rights. I want to just make 2 quick points. The first one is if we want to instill a sense of confidence in our judicial systems, a number of things need to happen. And similar to what was said about what the president of South Africa said about protecting the independence of the judiciary, our president actually has on a number of occasions every year when there's the opening of the legal year, our president would also speak about the importance of protecting the independence of the judiciary, and actually at that platform affirm the executive's commitment to ensure that that independence is continued to be safeguarded. But I did want to make an additional point, and that is, I think there are 2 other ways of ensuring that people have confidence in the independence of the judiciary. The number of those ones are open courts is one way where people have access and they can see how the process happens and even see how the legal profession participates in getting to the judgments that we'd like to see as a society. But something that came up in Namibia, when we were appointing the Prosecutor General was the question about an appointment process. And an open one, where, similar to what happens, I think, in South Africa, where the process of appointing judges, for instance, could become open, where the public participates, maybe even ask questions, or that the panel is familiar with the kinds of questions that the public would like to see. So an open appointment process may be one way, Chidi, that I think we want to encourage some form of judicial independence in our various countries. The other issues, I think, everyone is familiar with. What would ensure that the safeguards that we have in place for the judiciary to be independent are ones that members of the public are also familiar with, but also one that they themselves support.
Thank you. Thank you ever so much, Honorable Minister. I mean, it's good to see positive forces in these positions in different countries. Matthew Sake, I hope I did not murder the surname. You have the floor, 90 seconds. Can someone please unmute Matthew? Monsieur Sake? Yvonne, please. Can you help us? Matthew Sake? Can I also actually request an insight from Arnold Sunga, who was the regional director of International Commission of Jurists for Africa, and has also been a parliamentarian in Zimbabwe. One, because he's Zimbabwean and Zimbabwe has a deep position on these issues. Secondly, because of the fact that he's been a politician, comrade. And thirdly, because of his work at ICJ. Arnold, I'm sure you bring some terrific and unique insights on this issue, and I think we'll be remiss if we did not hear from you. can someone please unmute Arnold? Hello? And after Arnold, we'll probably take not more than one more contribution, and we'll have to see the floor back for the conclusions. Sophia, please, can someone help us get Arnold and Mr. Sake?
Right.
Hello? Yes, Arnold, please.
Can you hear me, Chidi?
Yes, yes, I can. I
Good.
hope others do too.
Yeah,
Thanks.
no, thank you very much. And thanks to the coalition and to Palu for organizing and yourself for supporting the meeting. So yeah, I listened very intently, and it's very difficult to say that I can come up with anything that is different from the grain. But if I was to be asked to be maybe, what do you call it? Someone who provokes maybe the thinking, since you said I must also wear my political hat, Chidi. You know, the principles that we talk about, you know, the rule of law principles, independence of the judiciary, and the need for those who generally are perceived to be on the right side of the rule of law framework, especially when they have power, like sitting presidents who speak in defense of judicial independence, or maybe sitting judges who speak in defense of the rule of law. I think the assumption we then make is that maybe when they speak, so they have a very strong belief in independence of the judiciary, and that maybe they're also not driven by their own personal or self-interests, which may actually be narrow and not necessarily interests that are consistent with the value system that make us believe that in the enterprise of separation of powers and the enterprise of implementation of the rule of law, we make the assumption that the judiciary is central, and that the judiciary, central as it is, it needs to be depicting those characteristics of institutional independence and then individual independence of the judges themselves. But then, as Chief Justice Willie Mutunga aptly said, in terms of the visible and invisible forces that influence behavior of human beings, including the behavior of judges, there is always a possibility that the political economy of positions that are taken in presentations of what may look as virtue or good positions could actually be hiding deeper political and economic and ideological contestations. So that's why sometimes I hesitate to say this one is right and this one is wrong, especially when you have no clear understanding of the actual driving forces behind positions. So suffice to say that especially in countries that have experienced deep conflict, as well as serial inequality and injustice, and maybe poverty that is driven through you know, conquest, historical factors, including colonialism. Sometimes the fight for the control of the heart and soul of the judiciary, including the behavior of the judiciary, in then shaping the political direction countries take, we need a deeper, nuanced look at it. But otherwise, from a rule of law and a former ICJ Africa director, I would totally agree that we have to defend independence of the judiciary, both institutional and individual, and that independence is also intricately linked to independence of the legal profession, because without an independent legal profession, you cannot get an independent judiciary. That's what I can say, Chidi. Thanks, back to you.
Thanks ever so much. There is a message here about the Sudan, a question about the Sudan Bar Association. Maître Fathia, do you want to just present that, please? And then we round up.
Merci. Je dis, en effet, il s'agit d'une question qui a été posée et qui nous a été soumise, qui a été soumise au PALU dans le cadre de la dissolution du barreau du Soudan, suite à la loi du démantèlement qui a été promulguée par l'État soudanais. Et donc, ça, c'est une question qui touche vraiment l'indépendance, non seulement l'indépendance de la profession juridique, mais elle porte atteinte à l'intégrité des barreaux, parce que le barreau du Soudan, il a été élu dans le cadre des élections légitimes. Ils ont même fait l'objet d'observations par l'Union des avocats arabes. Et donc, tout à l'heure, notre consoeur, je crois, Moya, elle a évoqué la question. Donc, elle a parlé du silence, de notre devoir. Il faut que nous brisions le silence et oser parler. Parce que lorsqu'il s'agit de dissoudre une association de barreaux, ce n'est pas une association, c'est un ordre des barreaux des avocats qui a été dissous. Et au prétexte qu'il s'agit d'une loi qui démantèle toutes les institutions. Nous savons que ça, c'est une première. C'est une première dans le monde. Donc, Bâtonnier Osman demande des commentaires et c'est pour cela que j'ai soumis cette question, donc, pour solliciter le commentaire de nos avocats, de nos confrères avocats. Surtout que lorsqu'il y a une iction du pouvoir exécutif dans la profession d'avocat, cela menace non seulement la profession juridique, mais également, non seulement, je voulais dire, l'indépendance du pouvoir du système judiciaire, mais également notre profession. Donc, nous ne pouvons pas nier qu'il y a une interconnexion, interconnexion, comme l'a évoqué également notre consoeur tout à l'heure, interconnexion entre le système judiciaire et la profession juridique tout entière. Donc, s'il y a des commentaires, cette question, il a été évoquée, je l'ai tout à l'heure évoquée, et j'aimerais bien solliciter l'avis de nos consoeurs, de nos confrères avocats et bien sûr les panélistes. Merci.
Thank you very much, ma'am. So you saw that the dissolution of the Sudan Bar Association by explicit ad hominem decree of government is the issue that's been raised here. And how do we fight that? It's an example of independence of the legal profession, but that's not just that. The case of Fatma Karume in Tanzania has been mentioned because that's the lawyer who was, whom the legal profession in Tanzania, in cahoots with the government of President Magufuli, decided to disbar because of her free expression exercised both in court and on Twitter. In Sierra Leone as well, some of you may have followed the case of another lawyer whom the Supreme Court of Sierra Leone decided to convict for contempt of court, again, because of exercise of political expression, entirely outside the face of the court and in violation of the relevant and applicable procedures and principles. But I think I'm going to turn this over now because we are really well beyond our time, to my colleague and big brother, Ibrahim Khan, to round us off. And I just wanted to say thank you, but also to point out that some useful agendas have emerged, certainly on implementation of judgments, on financial autonomy as an element of independence. Sorry?
Juste une remarque. Je dois faire remarquer justement que l'affaire a été portée à la Commission africaine des droits de l'homme et des peuples, donc pour annulation de cette décision qui est contraire à la constitution soudanaise. Juste cette remarque. Parce que le Soudan n'a pas, vous savez que le Soudan n'a pas fait la déclaration qui est prévue dans la Charte africaine des droits de l'homme et des peuples. Et donc, la Cour africaine des droits des peuples des droits de l'homme et des peuples ne peut pas être saisie du dossier. Et c'est la raison pour laquelle elle a été soumise à la Commission pour justement la soumettre à la Cour. Mais malheureusement, il n'y a pas eu de suite. Il y a aussi une lenteur par rapport aux décisions de la Commission. C'est dommage aussi, ça, c'est un handicap qui menace encore plus le corps de notre métier. Merci et je ne vous interromps plus. Merci beaucoup.
Okay. I should point out, of course, that we've had with us in this meeting two former presidents of the African Commission on Human and People's Rights, Maître Maïga, and Her Excellency Justice Sanji Monakeng of Botswana. And hopefully what we're doing is we are harvesting all the questions which will go into the reporting and which will also come back to all the participants here, because we have the email of every participant. And so we're going to engage in mutual dialogue to try and see how we structure a response and develop an agenda from this. As I was saying, that agenda, some of the advocacy will extend to financial autonomy issues, implementation of judgments and disregard of judgments of courts, and also questions of standards of appointment and procedures for appointment of judges. I think those three come out very clearly as three major areas of action. The questions of capture and how they are done and how to respond to those may require additional attention and may well require additional evidence in specific cases of allegation. And then there are points about solidarity with the legal profession as we go along. Let me hand over now to my big brother, Ibrahim Khan, to please bring us to an end. And thank you, colleagues from around our continent and beyond again. Well, thank you. Ibrahima?
Merci, Chidi. Merci pour tout le travail qui a été fait pendant ces 3 heures de temps durant lesquelles on a vraiment eu à connaître tous les aspects de l'indépendance de la justice, mais aussi des professions juridiques en Afrique. Ces remerciements vont d'abord à la coalition qui a bien voulu organiser ce webinaire et qui a bien voulu associer l'organisation des avocats du continent qui est PALU pour discuter de cette question. Vous conviendrez tous avec moi que les 3 heures de conversation nous ont permis de partager nos vues sur la problématique de l'indépendance de la justice sur notre continent. On a eu un aperçu de ce qui se fait un peu partout sur le continent, mais aussi ce qui se fait à travers les systèmes juridiques que nous avons hérités des systèmes coloniaux qu'on a connus par le passé. Tout n'est pas rose. Au contraire, on a beaucoup de raisons de s'alarmer sur le respect de l'état de droit dans nos pays à partir des expériences qui ont été soulevées de part et d'autre. Mais aussi, on doit souligner qu'il y a des bonnes pratiques sur le continent qui donnent à espérer que si nous travaillons à partir de ces bonnes pratiques, notamment relevées par la ministre de la Justice de Namibie et par d'autres collègues aussi, on peut espérer que l'Afrique va redorer son blason sur la question de l'indépendance de la justice. Parce que ce n'est pas seulement à l'intérieur des États que les actions sont entreprises, mais c'est aussi au niveau des mécanismes que nous avons au niveau régional avec la Cour de justice de la CEDEAO, la Cour de justice des États de l'Afrique de l'Est, et aussi au niveau des organismes continentaux tels que la Commission africaine des droits de l'homme et la Cour africaine des droits de l'homme. Donc, il y a beaucoup de raisons d'espérer et c'est à partir de ces bonnes pratiques-là que l'on doit vraiment travailler pour faire avancer la cause, pour faire bouger les lignes, notamment en développant la solidarité. Et ces rencontres ont justement pour vocation de vraiment créer des liens solidaires entre les juges, entre les avocats, entre les militants des droits de l'homme, pour que nous puissions ensemble créer un vrai mouvement pour la défense non seulement de l'indépendance de la justice dans nos pays, mais aussi pour protéger les professions juridiques qui sont vraiment les outils qu'on utilise devant les juridictions pour davantage protéger les droits qui nous sont reconnus, notamment par la Charte africaine des droits de l'homme et des peuples. Donc, chers collègues, nous avons là les éléments qui vont nous permettre de travailler sur cette question. Donc, l'encouragement que je ferai à une organisation comme la coalition, c'est de prendre les 5 ou 6 éléments que Chidi a clairement identifiés comme étant des éléments que nous partageons tous en termes de préoccupation, pour qu'on puisse les examiner les uns après les autres, de manière à faire non seulement bouger les lignes au niveau de nos États, mais aussi à faire avancer la cause au niveau du continent. Et j'espère que la coalition, avec sa nouvelle équipe, va davantage travailler sur ça et va vraiment œuvrer pour que ce que nous avons commencé aujourd'hui se poursuive, se renforce et surtout que nous appelions d'autres acteurs qui n'ont pas été présents aujourd'hui à venir renforcer nos rangs pour que nous puissions aller dans la direction que vous avez vous-même déterminée. Alors, le souhait vraiment est que cette réunion, ce débat soit considéré comme le point de départ d'une nouvelle orientation de nos actions dans le domaine de l'indépendance de la justice. La présence des commissaires et des juges à cette rencontre, des commissaires de la Commission africaine et des juges de la Cour, ou en tout cas du personnel de la Cour, pour moi, doit aussi être très encourageant. Parce que ce que nous disons ici, ils l'ont entendu. J'espère que ce n'est pas entré dans les oreilles de sourds et que même au niveau de la Commission, ils feront tout pour que nous puissions travailler en communion pour que l'indépendance de la justice sur notre continent soit une réalité et que cette indépendance-là puisse faire vraiment bouger les lignes pour le respect de l'état de droit. Le thème de la réunion, c'était que la justice était aussi un moyen de récession démocratique. Mais on voudrait que la justice soit un moyen de la découverte de l'état de droit ou du renforcement de l'état de droit. C'était pour cette raison-là qu'on a organisé cette réunion et c'est dans cet esprit-là qu'on pense que nous allons continuer à travailler ensemble, nous allons continuer à partager nos expériences et nous allons continuer à créer vraiment des ponts entre nos différentes professions, à créer des ponts entre nos différents pays pour que l'indépendance de la justice soit vraiment une réalité. Encore une fois, je remercie tous les participants qui ont bien voulu prendre de leur temps pour assister à cette rencontre, d'avoir vraiment contribué à éclairer nos lanternes sur les problèmes que rencontrent les juges et les avocats, avocates bien sûr, sur le continent, que nous sommes avec eux et avec elles, que nous allons contribuer non seulement à leur indépendance, mais aussi nous allons contribuer à leur assurer une meilleure sécurité dans la profession qu'ils ont choisie, c'est-à-dire défendre la dignité et la vie humaine sur notre continent. Donc, c'est avec ces mots que je voudrais vraiment rendre la parole à, je ne sais pas qui va vraiment clôturer définitivement la session, en espérant que la prochaine réunion sera beaucoup plus technique et qu'on pourra mobiliser davantage de personnes. Merci Chidi et aux membres de la coalition pour l'organisation de cette activité qui a vraiment été une réussite totale. Merci beaucoup.
Ibrahima, you're to bring it to a close. Don requests that you please do so.
OK. Et donc, par conséquent, je remercie tout le monde et je vous souhaite non seulement une bonne fin de semaine, mais surtout que l'on se retrouve très bientôt pour discuter d'autres questions qui sont afférentes à l'indépendance de la justice et à l'état, en tout cas au renforcement de l'état de droit sur notre continent. Bon week-end et à très, très bientôt. Au revoir au nom de la coalition. Merci beaucoup. Allez, bye bye.
Au nom du PALU, est-ce que je peux aussi remettre qu'il me soit permis?
Tout à fait, madame. Allez.
Parce que je crois que Donald s'est excusé, alors je dois à mon tour remercier tous les participants pour avoir donné de leur temps et nous consacrer donc et nous échanger sur un thème aussi important que récurrent, parce que l'indépendance du pouvoir judiciaire, qu'on le veuille ou pas, soulève plusieurs problèmes que nous avons probablement nous tous été confrontés et comme vient de dire notre collègue Ibrahim, j'espère que ce séminaire ou cette rencontre soit un début d'un mouvement un mouvement solide, un mouvement qui rapproche le corps des magistrats aux avocats, parce que après tout, nous sommes tous au service de la justice et c'est une mission noble qui mérite d'être défendue. Et cette amitié, c'est une mission donc qui ne peut s'autoriser le silence. Voilà, donc nous avons intérêt à briser le silence et oser affronter des sujets qui sont d'intérêt pour nous tous. Merci. Au nom du PALU, je vous remercie de nouveau. Merci à tous les panélistes et à très bientôt.
Au revoir et à très bientôt. Merci, madame, pour les mots de fin. Merci. Allez, au revoir.
Au revoir. OK.